Okay, good evening, everybody. My name's Tom Lee, Chairman, Vice Chair, but acting as the chair tonight. Our chair is out. So this is official call to order at 6:01 PM for the Town of Alton Zoning Board of Adjustment, public hearing on Thursday, June 5th, 2025, at the Alton Town Hall. First order of business is the appointment of alternates. Could we get a motion for Mr. Manzioni?
Make a motion to appoint Mr. Manzioni on the board this evening.
I'll second it.
All in favor?
Aye.
Aye. Okay, welcome aboard, Paul. All right, the statement of the appeal process, I'll read through this and then we'll get into the cases. The purpose of this hearing is to allow anyone concerned with an appeal to the Zoning Board of Adjustment to present evidence for or against the appeal. This evidence may be in the form of an opinion rather than an established fact. However, it should support the grounds that the board must consider when making a determination. Purpose of the hearing is not to gauge the sentiment of the public or to hear personal reasons why individuals are for or against an appeal, but all facts and opinions based on reasonable assumptions will be considered. In the case of an appeal for a variance, the board must determine facts bearing upon the 5 criteria set forth in the state's statutes. For a special exception, the board must ascertain whether each of the standards set forth in the zoning ordinance have been or will be met. All right, with that, we're looking for an approval of the agenda, but Norma, is there any changes to the current agenda?
We have made a small adjustment to case number Z25-15 for Eagles Way. There is a variance that is not applicable, which is number 3 on the request sheet on the staff review. That's basically a duplication of the one previous to it. We determined that at last meeting.
Okay.
That's all.
Okay. Do we have a motion to approve the amended agenda as is?
I'll move that we approve the agenda for this evening as amended.
I'll second.
All in favor?
Aye.
Aye.
The first case for tonight, KZ 25-12, Changing Seasons Engineering. Stephanie Richard, agent for Richard Lundy, the owner, map 15, lot 931, Miramichi Hill Road, for a special exception in the residential rural zone. The applicant is asked for a continuation until next month's meeting, which is on 7/10/25.
So move that we approve the request of the applicant to continue that case until next month.
Second.
May I, before there's a vote, just for the record, state that I'm recused on this case.
Okay. All in favor?
Aye.
Aye.
We'll move right along to case number 2, which is a continued application from May 1st, 2025. KC 25-18, Robert Miller and Rich Chelman, agents for Rich Casal Family, 2005 Irrevocable Trust, Richard Casal trustee, map 16, lots 18 and 20, Cherry Valley Road. Administrative appeal in the rural zone. An administrative appeal is requested in reference to the planning board's interpretation of the Alton zoning ordinance on 2/18/25 for Article 400, Sections 452B and D. Okay, we don't need to go through an application. Are the parties available for KZ 25-18? Yeah. Okay.
Mr. Chairman, I'm also recused on this case.
Okay.
Excuse me.
turn that microphone on.
Yeah, just press the button.
So that it's green?
Keep both buttons so we can hear you.
Green is good, got it. Okay, so again, I'm John Bisson for Lakes Hospitality Group, the owner of the property at issue in the appeal. And I'm just here to essentially object to the continuance, because as I understand it procedurally, the public hearing was completed at the last session, such that at the conclusion of the meeting, you were in deliberations. And so there really is no need for anybody to participate from the public. So the fact that representatives on behalf of the appellant aren't available really has no bearing on your decision-making process. You had everything, you heard the hearing, and you can deliberate and conclude without, basically without anything from us. My concern, our concern is that this has been a very labored process to get here, and whether there's some desire to simply delay the process is a concern to us. So we would hope that you would look at the record, and if I am correct that you were in deliberations, there's no basis to continue your deliberations because you need nothing from the public. And we would ask you to finish your deliberations and issue a decision. And I suspect that the applicant on appeal will continue to pursue whatever legal challenges that they think they have. They've already filed in the Belknap County Superior Court as well as the Hillsborough County Superior Court. So they're not without legal avenues. That's all I have to say, really.
Okay.
Thank you all.
Thank you, Mr. Bisson. Is there anybody here in regards to Mr. Miller or Mr. Chalman for the Cassell family? Okay, that would be a no. All right, at this point, I will open it up to any public input. If anybody is,
Mr. Chairman, I think maybe first we should consider whether we're going to grant the continuance or not before we go further in the hearing.
okay,
I think the appellant has known about this for a month. He comes from a fair-sized law firm, which should have been able to find somebody to come here this evening. And I really agree with the original applicant that maybe a delay here is something that they're seeking in a roundabout way. So my position would be that I would not grant the continuance that's requested by the appellant.
okay,
So I'll move, therefore, that we deny the motion or the request for a continuance and go forward with the deliberation after public input.
okay. Any other comments?
I will second that.
Okay.
For the record.
So we have a denial of the continuance. We can take a vote on it. Joe, where do you stand?
I agree.
Tim agrees. Paul, you agree with?
I agree.
Denying it.
I agree with denying it as well.
I as well, so it's unanimous that all four representatives deny going forward with a continuance. All right, as far as the deliberation, I'll then open it up.
Chairman, it's a public hearing, and I read over the minutes before coming in this afternoon, and I think we got as far as pausing the hearing last month to allow us to talk to our counsel about the matter, but I don't think we ever opened it up to public input, and since it's a public hearing, I think that would be an appropriate next step.
I agree. And council has also informed us that would be the appropriate step to take. It certainly doesn't hurt. So I'd like to open it up for any public input. Anybody in the public in regards to this case that is in favor, of this case, would you please come forward, state your name? Okay, that would be no. And is there anybody in the public that's in opposition to this case? If you'd please come forward, state your name. Again, that's a no. So at this point, I'll close it to any public input. All right, as far as the deliberations here, we can go through the segments for the RSA
Yes,
452B and the RSA 452D.
correct.
Um,
Mr. Chairman, it's my feeling that this town, the town of Alton, the planning board, and the zoning board of Alton have always interpreted 452B to mean that you have 200 feet of frontage on the road. And we've done that in all of the various zoning districts that require 200 feet. And what the appellant has proposed here is sort of a contorted Euclidean measurement of that. And he's reading language into the section which I don't believe is there. If it was there, there'd be some rules about how that measurement is taken, how close to the road it should be, how far away from the road, how many times it needs to be taken, how far back in the lot. There's none of that language in the ordinance at all. It simply says, and quite plainly says, that you need 200 feet of road frontage. So I don't agree with the appellant's interpretation, and I do agree with the planning board's findings.
I feel the same way. I feel as though that the planning board made the right decision, based on the ordinance itself and how it's always been handled through the years, with the wording. And like you said, and 452B does not include a requirement that a lot have right angles or a minimum number of feet wide, except for where the lot touches the street or highway at that angle, not on any right angle. Okay. Joe, your opinion?
I agree with that. There's nothing that defines the angles. It's 200 feet of frontage. And that's the rule we've followed forever, so I agree.
Okay. I'm also in agreement with what's been stated previously. I do not agree with the applicant's argument regarding section 452B's treatment of frontage. With that, that's unanimous that the ZBA agrees with the planning board's written findings stated in its written decision dated February 18, 2025, and hereby adopts those findings. Section 452B has the same frontage requirement as, for example, section 433D. Each section requires that a lot touch the street or highway line for a minimum number of feet. The word width in section 452B does not include a requirement that a lot have right angles to a minimum number of feet wide, except for the lot touches the street or highway. So in this case, the ZBA does not agree with Cassell's argument, and we are in agreement with the planning board on 452B. In regards to RSA 452D, minimal buildable area. Would you like to take it, Paul?
Yeah, I believe, with the planning board's written findings that state in the written decision dated February 18, 2025, and hereby adopts those findings. It set forth where intended to be excluded from the calculation of minimum buildable area, or if in the definition of building envelope was to be incorporated into section 452D. The voters knew how to do so and declined to do so. The calculation of minimum buildable area under section 452D does not exclude setbacks and does not incorporate the definition of building envelope. So in this, I agree with the planning board.
I agree with that interpretation.
I also agree.
I agree as well. So for 452D, the ZBA does not agree with the applicant's argument and does agree with the planning board's written decision.
At this point, Mr. Chairman, I'm going to make an overall motion that the ZBA interprets both section 452B and 452D in the same way as the planning board, that is not in concurrence with the appellant here, and that we deny the appeal.
Okay. Do we have a motion for denial?
Yes, that's my motion.
That's his motion.
And a second.
I'll second that motion.
Everyone in favor?
Use your microphone so we can hear something instead of just.
They're on.
mumbling.
They're on.
They are on.
They're on, this is the best we have.
This is the system we
I'm on
have,
the
and they
same
are
page.
on, sir. Can you hear us back there?
People in the back, can you hear
Everybody
us?
hear us back there?
They hear
I'm
us
sorry,
back
sir.
there.
They can hear us back there.
It's not the best system, though.
Okay, so Joe, your interpretation? You,
Yes,
you agree?
I agree, yes.
Okay, and I agree as well, so it's unanimous, that we overall vote to deny the. All right, so moving on, case number 3, I'll speak up, sir, if that helps. Case number 3 is a new application, continued from May 1st, 2025. Case Z25-19, Robert and Janet Broughton, the owners. Map 41, lot 31, 20 Sandpeep Lane. It's a variance in the Lakeshore Residential Zone. A variance is requested for Article 300, Section 327A2, to permit the construction of a garage within the 25-foot front setback. So parties could come up. Are you Robert and Janet?
Good evening, yes.
Okay,
We're the owners of 20 Sandpeep Lane.
all right, just hang on one second as we look over the application. Thank you. Yeah,
It's on, right?
Can you hear us a little better?
Chairman, I'll move that we accept application Z 2519 is complete.
Inc.
A second.
All in favor?
Aye.
Aye. All right, Robert and Janet, if you could speak to your case, please.
Sure, thank you, and good evening, everybody. As I mentioned, this is my wife Janet, we're the applicants. We live in 20 Sandpeep Lane. We're requesting a variance to build a garage within the road setback adjacent to Sandpeep Road, Sandpeep Lane. The garage will be located on an existing parking area that was constructed in 2021 and approved by DES Wetland Bureau under a dredge and fill permit. DES has informed us they have no issue with building in the same approved area. And this was provided in an email from David Price of the Wetland Bureau, who handled our permit. The building will be a single-story modular garage on a slab foundation. Due to our lot size and the abutting wetlands, there's no other location on the property to put a garage. There will be no impact to the abutting neighbors, and I've had conversations with them, and they're okay with the garage. There would be, if you look at the proposed plan, the location of the garage is the house is westerly facing, so it's in the northeast corner of the diagram. And we provided you with some garage specs and drawings that, which is similar to what we plan to build. So the garage size is 20 by 20, and it would be 6 feet off the road, Sandpeep Road, and it would be approximately 39 feet from the house. So with that, I'll turn it back over to you for discussion or questions.
ask a question?
Sure.
So in the narrative, it says that seeking road setback relief of 6 feet due to the space constraints of the
Sorry,
property.
up to 6 feet. So it'd be 6 feet off the road.
So this a right-of-way setback we're talking about, right?
Yes,
All right, which is it 25 feet?
it's normally 25 feet.
Normally 25 feet. So instead of being 25 feet off the right-of-way, you want to be only 6 feet off the right-of-way.
That's all we can do because of the wetland that's abutting the property.
Because you don't, the unique topographical layout of your property is such that you couldn't put that structure anywhere else.
That's correct.
And the right-of-way is what?
It's 12, it's, the deed is, it's
The
deeded
road-
as 10 feet and it's 12 feet.
So it's a private right-of-way?
Yeah,
It's not a public road,
it is not.
and it services other residential properties?
5 houses.
Okay.
Yeah.
And those people who the right-of-way services have not object, or at least to your knowledge?
So I've spoken to both of the abutters. They have no problem. My cousin is 2 doors down. She has no problem. The other one is really at the other end of the road before you get to my property, so there'd be actually absolutely no impact there either.
And how wide did you say the right-of-way is?
It's 12 feet.
And it's a
But
deeded right-of-way
It's
of 12
deeded
feet?
at 10 feet. But when we built the house and we finished building the house in 2023, we put a new road in. We had to tear up the road, so we put a new road in and we made it 12 feet.
I see. It's plowed?
No.
If it-
A section, I should say a section of it is plowed. And the area behind our house where this garage is going is, we do that with snow throwers. There's no plowing. We just can't, it's not feasible to bring plow in there.
What is the right-of-way access? What is the purpose of the right-of-way?
To get to the houses beyond my house.
Oh, that's how they get to the
Yes.
houses?
There's 2 houses beyond my house.
If it were to be plowed, what would happen to the snow if there's only 6 feet between your structure and a right-of-way?
Well, I cleared it all winter long this year. There's room to the side of the parking area on both sides. I can put snow.
Thank you.
Yep.
Yeah.
Any other?
Yes.
Go ahead.
What is the total height of the new structure of the garage?
So it's gonna be 10-foot walls and a 8-12 pitch. So I'm not exactly sure what that brings it to, but it's, probably 20, 25 feet. There's no houses behind us either. It's woods and
nothing.
it's swampland.
That's the swamp in the area back there,
basically,
so it's
yeah.
not blocking any views.
There would be no impact on anybody's view.
And if I may, I'm sorry,
Yeah,
you
no,
probably have
it's fine.
said this a million times already, but the dimensions of the garage structure are what again?
20 by 20?
20 by 20.
Yep.
Thank you.
It's essentially the size of the parking area that was approved by DES.
Thank you.
May I ask?
Yeah.
The retaining walls that are there with the proposed garage, that's going to remain?
That will remain, yes.
What are the height of those?
2
2 feet?
2 feet, yeah.
This is where you're already parking now. This is where you park your cars.
Correct. Yeah, so we're just kind of enclosing it.
Okay. Thank you.
You're welcome.
Any other comments from the board? No? Okay. It's all set? You good?
We're gonna go.
All right.
All
With
right.
that, I'll open it up at this point to public input. If there's anybody who is in favor of this proposal for this variance for case C 20 519, please come forward. Anybody in favor? That would be a no. And is there anybody in the public who is in opposition of this case? Please come forward. Again, that would be a no. At this point, I'll close the hearing to any public input. The board is all set. We'll go right to the worksheet. I'll start it off with public interest. The variance will not be contrary to public interest.
I agree.
I agree.
I agree.
I agree. I appreciate it.
The request is in harmony with the spirit of the zoning ordinance and the intent of the master plan, and with the convenience, health, safety, and character of the district within which it is proposed. This is a parking area being turned to a 20 by 20 garage. It is 6 feet from the property, from the road, but this is a reasonable request and allowable by a variance.
I agree.
I would agree. I think that the spirit of the zoning ordinance and intent of the master plan is with regard mostly to public rights of way, where a 25-foot setback makes sense. There's snow removal and all kinds of things. This is a private right-of-way, a deeded right-of-way. It's a parking area. I don't think that doing this would in any way be contrary to zoning.
I agree. By granting the variance, substantial justice will be done. I think the benefit to the applicant with this proposal far outweighs any detriment to the town of Bolton as a whole.
I agree with that.
I agree also.
I agree.
I agree.
Well, the request will not diminish the value of surrounding properties. There's nothing that we've been presented with that would indicate that. There's been no public input that would indicate that properties around there would be diminished by virtue of this structure.
I agree. I don't think it'll affect the value at all. So I'm in agreement.
I agree.
I agree for the same reasons.
I agree as well.
For the purposes of this subparagraph, unnecessary hardship means that owing to special condition of the property that distinguish it from other properties in the area. No fair and substantial relationship exists between the general public purposes and the ordinance provision and the specific application of that provision to the property. I agree, yes.
I agree.
I agree as well.
I agree. I think the wetlands here on this property make it difficult to put the garage anywhere else, and that's the hardship applicable to this property. And the proposed use is a reasonable one. It's covering over an existing parking area.
I agree with both of those things for the reasons I've stated previously, and the fact of the wetlands, and the proposed use is a reasonable one.
And I also agree with the proposed use being a reasonable one.
And I think, Mr. Chairman, we probably need to go with the other votes on the proposed use portion of that.
Okay.
Yeah.
As far as the proposed use, yeah, I believe it also is a reasonable one.
I agree.
I already stated my position. Mr. Chairman, I move that we approve application is the variance requested from Article 300, Section 327A2, with construction of a garage in application Z1519.
Well, second.
All in favor?
Aye.
Aye. Congratulations.
Thank you so much.
Take care. Have a good evening.
I don't know. And I know that.
Thanks for coming.
It's not in, I'm glad you have. It wasn't in front.
Okay, our next case is case Z25-20, Prospect Mountain Survey, Paul Zuzko, agent for Paulette C. Alden Brooks, 1997 trust, Paulette C. Alden Brooks, trustee. Map 27, Lot 4, 9 Barnes Ave,
24.
variance in the residential commercial zone. It's an equitable waiver is requested for Article 300, Section 327A to permit a new lot with an existing dwelling and deck in the setbacks and a variance is requested for Article 400, Section 443A1 to permit a new lot under with less than 15,000 minimal required lot area. Welcome, Paul.
Welcome.
Just state your name for the record.
Name's Paul Zusko. I'm here representing Ms. Brooks.
Okay, thank you. Give us 1 minute for your application.
All right.
Completeness.
Zusko, is there an agency letter in here that I'm missing, that I'm overlooking?
Yeah, I see it.
Can I make a motion to accept Z 25-20 for a equitable waiver and variance complete?
Second.
All in favor?
Aye.
Aye.
Okay, Paul.
So she's, if anybody here know who she is, she's getting up in age. She wants to be able to sell these lots. One house was built in 1930, one was built in 1940. Lot 5 is only 7,000 square feet. There's no way you can expand that. If someone were to buy that, they wouldn't be able to sit there, tear that house down, which is quite small, and build a 3-bedroom house. It's only lot loading for two bedrooms right now. Her house, which it's a horseshoe going around that lot. So what she wanted to do was do a lot line adjustment and make the lots look better, for one, and give lot 5 a backyard, which has really no backyard. So both lots would not, only one lot would be able to meet the 15,000. Oh, for one, it's in 2 different zones. So one is 15,000, one is a half an acre. So where do you go? Which zone do you do? The 15,000 or the half acre? So I went with the 15,000. Each lot, I tried to get them as equal as possible. I couldn't get both of them. There's not 30,000 square feet. So I made lot 5, I made it the 15,000, a little more, and I made lot 4, came out to be 13,000, which both lots now would meet state lot loading of 600 gallons a day. And it aesthetically makes the lots look better. Now, lot 4 was 21,000. I could have made that 15,000, the other one 13, but then lot 4 still would not have a backyard. I would have had to move that line between them 30 feet, which would then be right behind the house lot again. And at the same time, well, both garages right now are within the setbacks, and both houses are within the setbacks. So with the lot line adjustment, I made it so that both garages are now within the setbacks. And I can't do anything about the houses because they're in the front setback. But I did make the garages conforming. One lot is conforming for area, one is not.
Mr. Chairman, may I just ask a question?
Yep.
So the new proposed lot, one lot would be fully conforming other than setbacks in terms of square footage?
Yes.
Okay, yeah, that's what I thought. Mr. Chairman, may I just follow up? The 2 lots obviously predate zoning, which is why all the nonconformities exist on those lots, because today they would be nonconforming. If you weren't doing boundary line adjustments, they'd just stay the way they are and you wouldn't need any variances. And the only reason you need the variances is because you're doing two brand-new lots, which now puts them into zoning, and they require all these variances. You have to go to the planning board after this if.
And I have to get state subdivision approval for lot 4. Because it was 21,000 and I'm making it 13, so I'm making it smaller. But I still meet state lot loadings. The state is really trying to make housing better regulations because they've taken minimum lot size right out of their size. Yeah. They used to have minimum lot size. Now we just do it by the soils and lot loading. You just have to meet 600 gallons a day. And I think the lots look better this way. You're able to sell them better, and they can expand. That house built 1930 really needs to come down and new one put in.
That would require probably another variance, though.
I don't know, because then the new house would be built within the setbacks.
Oh, okay.
Which one is the 1930 house?
I think, I think lot 4 is the 1930 and lot 5 is the 1940.
And access to the road or whatever for each of these lots is not going to be affected by the
It's not going to change.
boundary line adjustment.
Nope.
Any other questions from the board?
No.
Anything further, Paul? Good?
I mean, I can show you just from 140 all the way to the cemetery. I can show you 12 lots that are under 10,000 square feet here in town. If it weren't for the great soils we have here in town, it wouldn't be that way.
Yeah. Okay. At this point, I'll open up a hearing to any public input that is in favor of this equitable waiver. That would be no. Is there anybody in the public who is in opposition to this equitable waiver? Also no. At this point, I'll close the hearing to any public input. We can then move to the equitable waiver with dimensional requirements worksheet.
Could I just ask a question before you close? It's an equitable waiver application. I thought it was a number of variances. The problem with this is some of these materials were provided at the last meeting, and I wasn't part of that, but I'm just wondering, I thought it was a number of variances for each of these things. Why is it an equitable waiver? Just so I understand that.
I think I started it as a variance, and then I think Norma called me and we changed it to an equitable waiver. That for the setbacks?
So-
Yes, the existing dwelling is within the setbacks. And they're changing.
That's an equitable waiver.
So they need a variance to make
For
it a
the lot
different
size.
lot. That's less than the required square footage, but they also are left with an existing dwelling in the setback.
When we go through the criteria for equitable waiver, won't it deal with things like the builder didn't know it and the town didn't know it and it all ended up that way? So typically someone's building a structure and it's 2 feet into the setback and it got constructed completely and the builder innocently didn't realize he was 2 feet and the building inspector or zone didn't know it was 2 feet. And then everybody discovers it after the fact. And they come in and they say, I need an equitable waiver because I'm in violation of zoning. And the criteria that we look at is, well, did you do it on purpose? Or was everybody innocent and it just happened and it would be really unjust to, it's only 2 feet. So, but here, these structures were grandfathered, absolutely nothing wrong with the way they exist because they were there before zoning. But now he's creating 2 brand new lots. And because they're 2 new lots, they have to comply with zoning. And they can't because the building's in violation. So instead, he seeks variances, and if the variances are granted, everything's fine. But I'm just a little puzzled about equitable waiver, because I'm not sure how we judge those criteria or find factual findings based on those criteria versus finding that they meet the criteria for variance.
So you would propose that each lot would have a variance because it ends up in the setback with the new lot.
Right, so one lot would need a variance because it's not enough square footage, the other lot is. And then one lot may need a variance because he's taken certain things out of the setback, so he wouldn't need, but there are some variances that are gonna be needed for these two new lots.
For the front setback, buildings right now are in the front setback.
Okay, so both buildings would need a variance for the front setback?
And lot 4 has part of the deck in the back is in the setback.
Right, so I think these are structural setbacks that now are needed, because if he creates two brand-new lots, any lot created after 19 blah, 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 has to comply with zoning. He's creating new lots, he can't comply with zoning, although I can see why equitable waiver would make sense too as a way to do it. But I don't think when we go through those criteria, they necessarily apply to this fact situation. And it could make it difficult for us to fit that in to our decision. So I'm not sure what to suggest, but I think what I was asking questions about, and I think what was being presented, were dealing with reasons why a variance would, should be granted, because he's created a need for them only by virtue of changing these two lots, which sounds like it's for the better anyway, the way the lots are. There are things becoming conforming that were non-conforming, and the non-conformities don't seem to be all that significant.
I think you might be right, and if she tries to sell one of these or both of them without the variance, there could be a problem with the title. If section 1, A1 of the equitable waiver says in violation been subdivided by conveyance to a bona fide purchaser for value, but they haven't been conveyed yet. The other.
If these were to be sold.
Pardon?
If these were to be sold, I don't think, I do a lot of mortgage inspections where these have been built prior to the zoning, they wouldn't find that. A mortgage company would still finance it, I believe.
Yeah, but it could run into a problem where after the two new lots are created, first of all, you can't create the two new lots with the planning board
Right.
until you get some relief from the ZBA. So these lots aren't even gonna get created unless there's a proper process here first, then you gotta go to the planning board and get approval. So, my big concern is, and I understand why equitable waiver was a consideration here, because in essence, you're seeking a relief, an equitable relief in a sense, but the criteria that are set forth in that, to me, are not applicable to the facts. So however, the criteria required for variance, I think, would be applicable to the facts, and we could go through the worksheet and deal with each of these lots as you've described them and laid out in the applications.
Are you suggesting then that the applicant withdraw the equitable waiver and just go forward with a variance?
Well, we need at least 2 variances, maybe 3. 2 for the front setbacks, 1 on 4 and 1 on 5. And then, which deck is it, Paul? that you-
4.
On 4.
4.
Yep.
Would that be the only variances? The rest of it's all in
And
compliance?
the lot size.
And lot
Lot
size?
4.
For lot
For
4,
one.
exactly. So procedurally, I'm not sure how this
minute, no.
No.
But he could go to the planning office and make an application.
This could be withdrawn, so there's no decision on it. And the same application could be submitted as variance application.
So just,
With the three
just
variants.
apply for all variant.
Right.
All three variants.
Or four variant, however many you need. And it would be the same documents because everything you've presented factually here is all applicable, at least from my perspective, to the variance criteria. So
What about the boundary line adjustment?
so what that deals with a variance for, his boundary line adjustments are gonna have to be approved by the planning board. And they won't plant it until he comes in and says, I've got all these variances, so I'm good. Then he goes there and sees if they allow the boundary line adjustment. We're not gonna do that.
Yeah.
But he's gonna need the variances to get that at the planning board.
You feel the same way about the equitable?
Do you have a worksheet for an equitable waiver?
I believe I filled it out, didn't I?
Well,
This is the worksheet.
the one.
You wanna take a look at it?
Oh,
And what it
I've
says.
seen it.
Yeah.
For the board.
I mean, it's like, if I'm voting on each of these, I mean, I don't know how I'm doing it. And I don't know how I'm saying yes or no to some of those, I think, if you read through.
I think when I answered it the first time, well, for the equitable waiver, all I said was when it, because why is it in the setbacks? Well, because it's been there since 1940. And it was before you even made setbacks.
Right.
So you're saying that equitable
You're
waiver is
correct.
only for an accident?
Yeah, well, for the criteria that are laid out here, because you don't have to worry about zoning for either of these lots or any of the structures, because they're all grandfathered, they're all legal, and you don't have to do anything with the
No, but
ZBA.
I'm trying to make new lots.
Exactly. So because you're creating two brand-new lots, now all of a sudden you got setback issues that
So
you have,
I did this before on Dudley Road,
right?
do a boundary line adjustment, came here because the house, which was there for 200 years, was in the front setback, and I got an equitable waiver for that.
I mean, we can go through the worksheet, we can look at it, but
No, it's just that, I mean, I was here last month. Now I don't want to know, I don't
see,
know if I want to make them wait another month.
number one,
And then be more than a month, because now I got to sit there and get the deadline in for the next meeting, which I don't know when that is.
here's number one, that the violation was not noticed or discovered by any owner, former owner, owner's agent or representative, or municipal officer until after a structure in violation had been substantially completed, or until after a lot or other division of land in violation had been subdivided by conveyance to a bona fide purchaser for value. So there are no violations.
But I'm making new lot line.
But I'm saying they don't exist. There are no violations right now. The lot.
Because they're grandfathered?
Because
Yes.
the zoning doesn't apply. So this isn't something where some owner's agent, representative, municipal officer says, oh, you built it, and now we discovered you're in violation. That's what that's saying. It doesn't apply to this, because right now you have no violations as you sit there. You have no violations. The only time they become in violation is if you create two brand-new lots. Once the planning board allows you to create two brand-new lots, now you're in violation of zoning, because you have to comply with zoning with new lot. So I'm just saying, these criteria, I would have trouble applying to this application in any intelligent way, because I'd be saying, what are we talking about?
All right.
But that's just me. You got
Yeah,
four
I
other
know.
guys here.
I know.
So what you're saying is he needs a variance? Because
think-
now he has a lot with a building in the setback, and that's a variance in this situation versus an
I-
equitable waiver.
I think that it's a situation where the plaintiff, it's not uncommon for applicants to come to the ZBA and seek relief that, you know, doesn't yet exist until they create a lot. And then they go to, like, especially subdivision situations, and, you know, so I think he gets conditional approval here, where then he goes to the planning board and says, I've got all these variances that are granted with regard to this subdivision. Because in essence, you're doing a minor subdivision with them,
Lot line adjustment.
lot line adjustment.
And Paul, if I remember, was Dudley Road the old schoolhouse?
The old corkscrew factory,
Okay.
way down,
But see
just by
that,
Grandview.
yeah, if I remember correctly, that was clearly an equitable waiver because the people purchased it not knowing that they were within a setback, if I remember correctly, without reviewing that whole case. That would make more sense. That would actually tie right into the questionnaire, that one of the ones that Paul brought up, so. And to your point, Norma, that's what Paul is referencing, this variances, no equitable waiver, which application, everything in the packet, status quo, except for the equitable.
Except for the equitable.
See,
At this point, we can't go through the other variances. The application. This is not spelled out on the application other than one.
So then I should probably withdraw this application and reapply for all variances.
It's looking more that way, yeah. It'd be the proper way of applying for this
Okay,
application.
and that's what we'll do.
If you could explain that well with her and them.
then there's no decision being rendered here
It's just a delay.
because it's withdrawn.
Right,
And then you get on for next month, and
okay.
And Paul, that's the same for the next case as well? For KC 21 as well?
That was the other lot, yeah.
Okay.
Yeah,
Yeah, it would affect that one.
yeah,
Well,
it would affect that one too.
Yes, it would.
Okay. All right, so just for the record, you're withdrawing KC 25-20.
Reapply of all variances.
Okay.
To the next meeting, which is July 7th. 10th?
When's the
7/10.
deadline? Our application deadline? When? Okay,
You don't really need any more materials.
No.
no, I just gotta redo the one sheet, the equitable waivers, change them to variances.
All right, can we get a
Probably
motion?
gotta reapply, gotta re-notify of more money.
You could also make application to this board for forgiveness of some of the fees at that time.
I was steered wrong. Because I did have variances.
You did?
I did.
that's why I say, I think,
And Norma called me and said we should go with an equitable waiver.
well, I think a request for whatever additional fees the town require, the board has the authority to waive those fees under the circumstances of this application. And then you probably will have to do re-notification of the same abutters, but now you're notifying them of an application for variance.
No, the butters aren't many.
Right.
Most of them are dead.
Do we need a motion
I
to?
would make a motion that the board allow, that the board waive any additional fees that may be required for the applicant to withdraw the current application and refile it for the next meeting as an application for appropriate variances. that the board waive any additional fees that would otherwise be required.
I would second that motion.
All in favor?
Aye.
That apply to 21 as well?
That motion would be made for 21 as well, yes.
Second for 21. All in favor?
Aye.
All right, Paul, see you next month.
Thank you.
Sorry about that.
Okay, our next case is a rehearing, KZ 25-15 Prospect Mountain Survey, Josh Tebow and Sean Dunphy. Agents for Walter Borowski, Living Trust, Walter and Janet Borowski, trustees. Map 6, Lot 1, Eagles Way, Falcon Drive and Osprey Road. It's a rehearing for a special exception and variances in the rural zone. Welcome. Your name, sir?
Good evening. My name is Sean Dunphy. I am the attorney for the owner of the property. Owners, Walter and Janice Borowski. And I will just point out that Mr. Borowski is here tonight in the back.
All right, just give us a second.
He didn't want to argue.
Sort of an appeal. Yeah. So we've already accepted this for rehearing, is that correct? You came before the board, requested a rehearing, and that was accepted, so this is
Yes.
this is the physical rehearing.
Yes, that is correct.
Yep.
Mr. Chairman, may I ask a question? Did I participate in that decision of the hearing?
I don't think you were
I
here.
did?
I think you were here.
Okay, thank you.
I
I'm
think you-
sorry that I don't.
I
know.
don't remember either.
Okay,
I
thank you for
apologize.
not remembering, then I don't feel so old. Thank you.
So the application was already accepted as complete. We don't need to go through that. So the first is a special exception is requested for Article 600, Section 602, C3 to permit an individual sewage disposal system within the Aquifer Protection Overlay District. So if you could speak to that, Mr. Dunphy.
Yes. Thank you. As was stated, we are here tonight on a rehearing request. So this application has now been before the board a few times. So I'm sure you're very familiar with the property. I don't want to belabor the background facts and use more time than I need to. I acknowledge that the last time we were here, things could have been explained a little better. And, I hope tonight with the additional facts that we come to a different result. But just to keep it more of a broad stroke. Again, this is 30 Eagles Way here in Alton. It's a manufactured housing community. The first request we are seeking tonight is the individual sewage, individual septic system in the Aquifer District. As I pointed out in my application, we raised the question of whether or not that application is required. But regardless of that question, based on what we've provided, we feel that we meet the criteria for that application. Specifically, the last time we were here, a question was raised about needing a hydrologist report and questions about protecting the water. Mr. Borowski feels the same way. He wants to make sure that the water is protected. He has tenants living on this property and wants to do everything possible to make sure that they're protected and the land is also protected. Because this property is serviced by a community water system, it is part of DES's water testing program. I provided it's good to the end of this month. And then Mr. Borowski has a certified operator that comes in and retests the water to make sure that it is clean and ready for use for the tenants. That is good until June 30th. And as I said, it'll come back. They'll come back for testing for the following year. That testing is routine. So that should hopefully dispel any concerns about things that come up within the aquifer zone. Additionally, this proposed septic system will be installed professionally. As was discussed at the last meeting, this property is large enough to contain the septic load. And overall, it's one additional unit that will be professionally installed, it will be monitored, and it will be one of the key pieces to provide an additional housing unit within the town of Alton, which, as we all know, is in desperate need at this point. Just a few additional things that I would like to point out. The density was an issue that was raised at the last meeting. This is, one part of the further applications that I will be presenting. I know, at the time that this community was created, the density was 1 acre per 1 unit. Now it's 2. But if you look at your master plan, which I provided a picture of, the community that Mr. Borowski has created is pretty similar to what is stated under the strive for this. So that's why we're here tonight, to try to, maintain this community, grow it modestly, and provide additional housing. And this is the first step. So thank you.
There are 2 units. One of them goes on a separate septic and the other goes,
The other unit, Unit 57, which is the other unit I'll be discussing during the variances, is outside the aquifer zone. So there isn't a special exception required for that particular individual septic system.
so it'll be on its own separate, but not within the aquifer.
Correct, yes.
Thank you.
Is there anything different or added to your application request from the last application? Has anything changed?
Yes, the additional studies that I provided from DES are what's changed. Do you mean substantively? I'm sorry. Yes, no, substantively it's the same. We provided the additional information to hopefully clarify some of the concerns about protecting the water.
First of all, you need the special exception.
Yes.
Okay, and in Article 600, Section 602C3, to permit an individual sewage disposal system within an aquifer protection overlay district, the state says the disposal of liquids and leachable wastes by a septic system receiving discharge other than that of a typical single-family domestic waste are prohibited unless special exception is approved by the zoning board. Can you explain to me how this is a typical septic system in this property?
Looking at this one particular unit, which is what's before you today, the other units that have already been installed have been approved. We're here tonight about one additional unit, and
Where 16 individual systems already exist.
which have, yes, been approved. And I raised the question, just putting it out there to ask the board for some guidance on that. It wasn't meant to, be anything. And my point is, even if, you decide that it is required, we've provided the additional info to hopefully make sure that, we've met your concerns. And I wanted this to be a collaborative effort, and hopefully we've met your, to show that this will be protected and there will be no issues to the water system.
Mr. Chairman, I think, just remembering what happened, I think I was an alternate that night, but I didn't participate in the voting, which is why, but, so I think that's what
Yes,
happened.
I remember that,
Yeah.
yes.
So you're asking for rehearing on a decision that was adverse to your application?
The board granted our rehearing request, so we're here tonight on the rehearing. So it basically starts anew. And,
So your rehearing isn't to say, you ruled one way and I would like a rehearing and see if I can change your mind and have you rule a different way?
Yes, so tonight we're here, yes, asking.
Right, so that's what I thought. So, the requirement for that is to show that the board's decision was somehow unreasonable or not based on, the evidence, or that the board committed an error when it made its decision, and that it's an unreasonable, I forget the specific criteria for establishing that what the board did the first time you were here is wrong, and they should reverse and rule in your favor tonight. And I think the burden is on the applicant to show the board why that decision was unreasonable or whatever those criteria are.
Well, last month, this board did vote to grant us a rehearing, so that standard was met at the last meeting. It was determined, and that's why we're here tonight to do the rehearing.
Oh,
So that's already been settled. We're here
Oh.
tonight requesting a review and the standard. Yes.
Okay.
So it.
I gotcha. Thank you.
yes.
Thank you.
So what is it new that you're presenting tonight then, other than the DES, the survey?
It's that additional information, it's the testing, I provided the certificate, so that's what we have, and, like I said, we've already, the board has already determined that a rehearing was appropriate, so we're here tonight to re-present the case, and.
Right.
It was my understanding you would have more physical evidence of a change or something else to add to your request.
In order to be granted a rehearing, which is what the board did. Tonight, we're here, and I provided, like I said, the DES packet. So we've already met that standard, and we're here tonight on this is a new hearing.
And looking at this, the hydrologist was not present and was not hired to.
No, because
of the water testing,
correct, yes, he's already doing testing.
which is two different things. A water test is not a soil test.
If you read the statute, it says that the zoning board can retain that. It hasn't been asked of us. We provided what we felt was sufficient evidence to show that there are no issues with this, and it will continue to be monitored. As I said, the DES will approve every step of this septic system.
And one of the issues I've had from the beginning, from the get-go, was that this is the request for special exception. This is not a typical system. This is not your typical lots, your typical systems in an aquifer protected area.
Yes, and that's why there's DES testing, which watches over this property. There's the community water system, and to date, there hasn't been issues. It's been passed. So I fully understand your concerns, and we have the same ones. We want to make sure that the water, it's not good for a landlord to have his tenants get sick because the water isn't good. So that's why we're doing the testing, and we've provided that info to the board.
But the testing you do, you're doing it on your own. Not,
It's a company that comes in and does it.
but you're doing it for your own interests. Your hand is not being forced to do
It
this
is.
testing. It is.
Through DES, it is. It's a
So they
community
require
water
you to
system.
come in, they require someone to come in X amount of times a year.
Yes, it's all laid out in the DES regulations for a
Because
community.
it's a concern, we don't want to overburden the land and contaminate the drinkable water, correct?
Yeah, it's a community water system that people rely on. We want to make sure it's safe, so that's why DES has a
And
testing
now we want
program.
to add another septic system to this area that's already a concern.
Right, and no, DES has already reviewed the septic system. It's been approved, so it is allowed per the state. We're here tonight for this special exception. So DES is aware of this additional unit going in, and there was no concerns raised from their aspect.
Mr. Duffy, if you could just refresh my recollection for me, what happened with the variance requests that night?
So two of them were denied, and I believe the third one just didn't end up get, or I think all three were denied that night based on this decision here, if I remember correctly.
So your rehearing request is for the special exception and the variance?
Correct, yes. And I thank Ms. Dietrich for clarifying that one of them isn't required, so we're here tonight for 2 variance requests as well.
Okay. And what can you tell, what new information can you give us with respect to the variances that were denied?
For the variances? Sure. The first variance we were requesting is a density variance, which is to allow for the 2 additional units to be within the rural zone. Since you're just asking for additional information, I won't go through the entire application.
Sure.
As I cited in my additional narrative, this property was developed at a time when the density was one house per 1 acre. It was designed that way. Mr. Borowski intended to continue developing this property. He's currently looking for 2 additional units. It was based on, the need of the community to try to keep the rent at a certain level. The additional information I provided was the various sections in the master plan, where it discusses the need for housing in Alton. Mr. Borowski's community caters to more of an older crowd. 55 plus is the majority of what he has. There's a big need for that type of housing. When it comes to people wanting to downsize, this is the exact type of community they'd be looking for. It's within the goals of the master plan. And as I said, the master plan shows a picture where it says strive for this, and there's a whole section about why this type of housing is more appropriate to conserve the natural beauty of Alton, to make sure that housing is accounted for and that there is open space. This is a 57-acre parcel where the units provide for lawns and things for the people occupying it that they can maintain, kind of personalized. And then if you look around it, there's a lot of open space. There's buffering between the abutting properties. So it's a very self-contained community. It's a private road. Mr. Borowski maintains it, plows it on its own. So there's, as I said, there's a community water system. Each unit has its own septic, and then there's a community septic for certain units. So there's no, more of a burden on town amenities and town utilities. And it's a unique parcel in terms of Alton because there's limited manufactured housing options in this town. And that's a type of housing the state of New Hampshire has made it known through RSA 67432 that it's a type of housing in demand, it's affordable, and that there's a push for communities to make for reasonable accommodation to expand that type of housing. So that's
A couple more questions. Under the ordinances now, it says this wouldn't have been possible.
without a variance, that's correct. But
There's now legislation before the state legislature that would change some of that. What are those changes? Are you familiar with them?
I'm not familiar with what's been passing and what's not. I know there's a lot of, there's an ordinance, a law that's being proposed that I believe it's manufactured housing should be allowed in every zone in any community. I don't know off the top of my head where it is, so I don't want to, give you wrong
The zoning
information.
now exists, this would not be possible, but perhaps if you came here in 6 months, it would be possible?
I don't know. I can't speak to what Concord's going to do. I think the need is now. I think based on what we've presented,
But based on the ordinances, it is now.
which is why we're requesting a variance and trying to show that this use is reasonable based on everything that I've said. It's a reasonable use. It's within the public interest.
The hardship be.
The hardship is This property was developed back in the 80s. This, it was made at a time when this density wouldn't be an issue for 57 acres, 57 homes on 57 acres. And when, I know that this came up at the last meeting, and I just want to clarify that for hardship, there's the two tests, which is based on unique circumstances of the land, strict adherence to the zoning ordinance, isn't appropriate, and whether the use is reasonable. And in this case, as I said, this property is made for this type of use. It's set up for it already. It was set up at a time when this could have been done. And that's the hardship, is that this is a reasonable use for this property. It provides for a public need, and that's why we're here tonight.
Thank you.
Mr. Chairman, I would like to perhaps redirect us back to the requests at hand. We started out with a special exception, went on to a variance, got into some other issues that aren't really related to the special exception. I just feel like maybe we need to go back to that. Address these in order.
Again, there were two individual sewage disposal systems that were approved by DES.
I know the one over the aquifer was, I would, and
You don't know about the other one.
I would have to check about the other one. I believe it is, though.
Do you know if these systems, the existing systems, the 16 individual and the community, where they inspected how they were working currently, and why none of these two new developments to the property not tied into the existing system?
To the community system. The community system was set up for the original Phase 1 development, which I believe was about 30 units. So that one is at where it was designed. Yeah, so that one, but it's working properly. There's been no signs of failure. And then the additional single unit ones that are also on the property have also been working properly. There's been no appearances that there are any issues. And again, I just go back to the fact that this property is tested more than most people's single-family homes are tested. So if there's an issue, they're going to know.
Thank you.
So 57 homes are already there.
Right now, there is 55. One of the 56 unit is there. It's not set up. There's no one living there.
The two are under construction or planned.
Not under construction. Unit 56 is there. It is currently empty, and it's ready to be used, but it hasn't. We've made sure that we're coming here before anything further happens. And then the 57th unit is going to go where a current recreational vehicle is on the property.
That's the one off to the side. It's kind of.
Yes, yeah, we're going to remove the RV and put in the correct home.
But you only had a permit for 28 houses. Well, whenever they built them, it was supposed to only be 28, but they ended up putting in 57. Am I understanding that right?
No, so the wording on the actual, I'm sorry, did I cut someone off? The wording on the actual application is awkward, I agree, and I should have done more to make sure that was clear. There is permitting and approvals for 55 units on this property. The current density would allow for 28 under the 2-acre rule, but there is 55. Those are approved, all good. We're all set with those, and we're just requesting the 2 extra ones.
If people are residing in those.
Yes, yeah, it's a vibrant community. I
thought.
I don't know if anyone's taken a drive down there. It's a beautiful area. Mr. Borowski makes sure to make it nice.
I've seen the sign 1,000 times. I just never gone down there.
Oh, it's a really nice community for people looking to downsize or move into this beautiful town.
I just sticking with the special exception for a second. So at the end of the first application for special exception, it was denied. And then after it was denied, you brought an application to the board saying you would like them to rehear it. And in that application, you pointed out that if their decision was unlawful or unreasonable, then they should rehear it and correct anything that may be unlawful or unreasonable. Tonight is that rehearing. Am I right so far?
So when we're requesting a rehearing, we point out, things, it's either errors of the board or
Right.
new information that comes about. I can't speak to exactly why the board decided to rehear it based on the specifics, but we're here tonight on a rehearing, so it's as if we're representing it to the board.
Right, but here's the thing, everybody who gets denied doesn't get to come back, or it would never end, right? Everybody brings an application, and whatever the board decides is a final decision, unless there's a legal reason the applicant can say, I want to do it again. I didn't like the decision, I want to do it again. But you also have to show legal grounds, because otherwise, anybody who gets an adverse decision could just say, well, I'll come back next week and ask you to do it again. You argued to the board in a request for rehearing that their decision may have been unlawful or unreasonable. The board said, yeah, maybe it was. So let's give you a rehearing. At the rehearing, I think you should show whether it was unlawful, unreasonable, or whether there was additional information that heretofore was not available for you to have presented the first time, so that you can now show the board that when they denied the special exception, it was incorrect, or there are new reasons why it should be granted. And so I didn't vote on that last one because I was an alternate, but tonight I'm going to vote, and I just want to ask you on the special exception, what is it that the board got wrong the first time when they denied it? Or what is the additional information that would now justify the board to grant it? And I think if we focus on that, then we can decide whether you should get a different decision this evening than what you got on the first application.
Well, just to clarify again.
Yes.
We had the first hearing, we were denied. I think I wrote a 28-page document stating what I believe were the errors or additional information that could have been presented. We took that, presented it. The board said a rehearing is appropriate, so we get to rehear it and represent the case. Now, on rehearing, I've presented additional information. Respectfully, I don't agree that it's information that wasn't available. I think that that's a different standard I understand where you're getting that from. But tonight, we get to represent the case. And that's what I'm doing. And I've presented the additional.
But you represented the exact same case as of before. No action was taken, or there's no new information that we can review to make a different decision. Is that correct?
No, it's not correct,
Okay.
because I presented the DES reports, which is a question that was
You
raised.
didn't have before.
Correct.
DES
You did not have it before. There was a question raised about protecting the water quality.
That's right. I remember.
Yep, so we have those. I presented additional arguments. I pointed out things that I felt the board misconstrued. And again, the board agreed. So that's why we're here tonight.
Yep.
So we're representing the case, and I'm incorporating the additional info. I've represented the case.
So before it was the DES reports, I don't think we had those.
Correct.
And was the groundwater, the ground being tested for the last meeting?
Yes, it's been tested for as long as that community septic
It's been
system has
tested.
been required for DES.
Okay, we just didn't have that.
Correct.
Report. This time we have the report, and we know now that it's a regular scheduled thing. So I do
Yes.
remember that, but I just didn't remember it being a scheduled thing where they were coming in once, twice, whatever it is.
Yes, and I provided the last go-around, and I could have kept going. It's all on DES's one-stop website, so it goes all the way back from when that testing program started, so it's been years.
Okay. All right.
Another question is, why didn't you go with a administrative appeal
For which portion?
for this board for the decision of the last meeting instead of a rehearing?
Well, this is a situation.
because that's the proper avenue, is go for a rehearing, raise additional questions and arguments. And I know what you're asking about is my question about whether or not the special exception could have been required. By law, I have to raise every argument to the board to preserve it. So I raised it, and I understand and appreciate that there's some questions about that. And again, it's our position that it may not be required. I have, my client has a right to ask the board to, make a decision on that. As I think I said at the last hearing, there's a Bartlett analysis from the Bartlett v. Manchester case where implicit in every request to a ZBA is whether or not it was required in the first place. And it's not meant to be a, personal thing. It's just, I wanted to raise the question, and, it's what I have to do to protect my client's interest. And additionally, as I said, I just want to go back to, regardless of that, if the board says it's required, I think we meet the elements based on what we've presented.
I just think, for the record, and it would be good to clarify this, that on rehearing, you're required to present grounds that would entitle you to rehear. And then if the rehearing is granted, you are limited to those grounds. You don't start de novo and present the entire new case a second time by saying, you granted us a rehearing, so we're going to start from scratch and have a whole new rehearing. I think that on rehearing, you do preserve all of your rights in the petition for rehearing, but it doesn't necessarily involve the entire case unless your argument was in that petition that everything the board did was wrong, and so therefore everything is being reheard and you're getting a complete second bite at the apple. I think an application for rehearing would say, here are the things that you got wrong, and if a rehearing is granted, it focuses on those. I guess what you're saying is in the 28 pages, you raised the entire hearing, and so everything was wrong, and so now you're redoing the entire hearing.
No, I'm not saying that. I'm saying once we do the rehearing, it does start anew. We represent the application, and I understand you disagree with that.
I do. But I'm not going to interfere with that if that's how you're going to do it. For purposes of the record, I think you should be given that opportunity so it's noted on appeal. But I disagree. I think that your rehearing is restricted to the grounds that warrant a rehearing, that unless you said everything the board did was incorrect, and therefore that all provides grounds for a rehearing. But it's okay.
And that's not what the law says, but that's fine.
All right.
Mr. Chairman, can I chime in? There's a lot of talk about testing and DES and One Stop and what's available. So there's testing that was done, but that was on the water source from a community well. And what we're talking about tonight is septics that are in the aquifer protection zone. They're two very different things. So I think when you may have alluded to this a month or two ago, that we were talking about testing the soils to see if the septics had leached or caused issues. There hasn't been an answer to that, but whatever testing has been provided with these reports tonight are all for the water source. And any DES testing that was done was from the water. That was the source, and we're not talking about that. We're talking about the septics. I think that needs to be clear.
That's why I mentioned the hydrologist, the test of the soil and water, two different things. Testing the water.
And can I just speak to that? As I raised in my rehearing request, in the zoning ordinance, it says that the ZBA may approach and, get a hydrologist, and my client would pay for it. That hasn't been done yet. I know you raised it once, but you're one member. No one has done that. And if that's something that the board wants to discuss, I have my client here. I can ask him before, if that's going to be a basis for denial, we can work that out. But again, that's why we're here tonight. Hopefully we can figure something out.
In my opinion, as one member, I think a hydrologist is necessary to examine the soil. You can test the water all you want. That's not testing what the soil conditions are for the aquifer.
And if that's the decision of the board, as I said,
That's my opinion on it.
Yep. And
So that was our final discussion at the last meeting. It's written right here.
There was a strong basis for the
Yeah.
denial. I don't think I've heard anything that meets the threshold of convincing me that that part of the board's decision is incorrect.
So where do we go from there?
You want to take 5 minutes and talk to your client?
If the board is okay with that, I will request a.
Yeah.
All set.
If they're gonna do that, you're gonna need to continue anyway, then we can talk to council.
That's what we suggested. But here, yeah, so it's water in place. But now, maybe talk about your own stuff. But you know, you're gonna have us with everything. I mean, that's what you think. I don't know, because I wasn't, I said, thing. And then you got it delivered. And we discussed that. We talked to space. We just denied it. At least that gives us, comfort. It's a very part of it, saying that six individual to do separate. Then you would have, and I would agree, and you would see, if he said, no, nothing's, I can pretty well. This is good, 39 understand, can you show it? If he says, no, I'll do it, I drop my case with this. Then he got some Spanish rest. If the hydrologist, you're like, oh, that can be approved. Generations, right, the rains go. Yeah. That's cool. Don't make me such a fool, it's not good. Basic make them, yeah, we do that on a regular basis, which means you know, if it's in the well. It's not for it, what's the point of doing it once? But if they don't agree to have hydrologists. Because we can't come to these sit here. And it's a very dynamic area. It's a good. But we were talking about, I think that's the quality over time. We're talking about, right, like you look at it, every week, but 3 months, when plans great to do everything, then that sign by the board and the board would say, okay, we'll pay with this setback. It's difficult for the setback. The more you get up with, the more you. Yeah, should be done. We saw a good deal of
Go right ahead.
I don't want to interrupt.
Yes.
Yes. So thank you for giving us a minute to discuss that. My client would be agreeable to getting a hydrologist study if you would be willing to make it a contingency on an approval of tonight. So if you approve it tonight, we would go get a hydrologist report. And then, you know, if something comes back, we can come back and discuss it. If everything looks good, then we can move to the next steps.
We propose continue.
Um, as I said, the request would be to do it as a contingency to the approval, barring, you know, anything that comes up in that report. So if the board is amenable to the rest of our applications, we can make that part of the proposal. Because it sounds like that's the only thing that's really holding it up, and you know, we're willing to work with that, but we just want to make sure that we're still moving to the next steps as well.
I rather agree with Mr. Manzione's position that what should have happened in the rehearing is that you would come back and say, this item the board got wrong and this is how it's corrected. This item the board got wrong and this is what the proper answer is, rather than a whole smorgasbord representation. So I'm having a little difficulty with your counter proposal.
Well, again, that's not the standard on rehearing, so if that's the board's position, we'll deal with it, but that's not the correct standard.
I guess we can agree we don't agree with each other then.
But I think the main concern, again, is the hydrologist study. So if the board doesn't think that the new information we presented, which is new, I have presented new information, then we're willing to work with the board and go back and get the hydrologist study if the board feels that again, that feels like the biggest contentious thing. I understand you've got a procedural issue with it, but if we can go back to what we're requesting and the actual substantive concerns is the hydrologist, if we deal with that issue, I don't see how we can't move forward.
The question that I would have on that, though, is if you get a conditional approval of your application tonight, conditioned on the hydrologist report, what does that condition say? As opposed to if you continue the rehearing and you come in with the hydrologist report and it's a sound hydrologist report that demonstrates that the applicant can do this without any concerns for health of the aquifer, then you get an approval, unconditional, because so we have to fashion a condition on a conditional approval that somehow then we have to say, well, did the hydrologist report meet that condition or didn't it? Where the condition is amorphous, it's hard to specify. But if we continue this and you get the report and you come in, if the report does what you need it to do, then you would meet the criteria under the special exception, which I think then impacts the request for the variances as well. But I'm troubled by the condition that would be how the board would fashion that. And then just as an aside, and you don't even have to do this, but I would be curious as to your authority on what the scope of rehearing is because I think it's limited to your application, but it's 28 pages, so I'm not sure what was in that other than the whole thing. But I think when you do a rehearing application, you're limited in the rehearing to those things you've requested. But, okay. But anyway, that's fine. That's an aside. That's a procedural side. I think that'll be moot. But I'm just, this conditional thing troubles me because I'm not sure. Because then we'll be fighting over whether you met the condition or you didn't. Well, I don't want to be locked into that.
I think the question is, does the additional septic system pose a risk to the aquifer? If the hydrologist comes back and says, no, it doesn't, then we've met the obligation. If he comes back and says, yes, it does, then we can come back and discuss it.
I think we're getting to the same outcome.
I think that the board would have the opportunity to consider who the hydrologist was, whether the methodologies employed by the hydrologist were appropriate, whether the conclusion is sound and can be supported, as opposed to we've met the condition because John Doe, hydrologist, wrote this report and said what your condition required of us, and therefore we're entitled to the special exception. I think if this is continued and you agree in the interim to bring a hydrologist report to the board that the board can then look at and make a determination whether that hydrologist report is acceptable, as opposed to, unless the condition is upon an acceptable hydrologist report to the ZBA. But I'm not sure how we would fashion that.
Pursuant to your own ordinance, so it says the town has the right to engage a New Hampshire licensed hydrologist or soil scientist to demonstrate to the satisfaction of the zoning board of adjustment that there are adequate plans for providing wastewater. So the ordinance provides that you pick the person, my client pays for it. I'm sure that would be your town staff. I don't know if they have someone who they work with regularly but it's not, Joe Schmo hydrologist. It would be someone who's vetted by the town and approved by your own officials. So that is directly addressing what you're saying, which I get. I understand what you're saying. But in this scenario, it would be the town choosing the person.
I'm not comfortable with this counter proposal.
No, I would still say that I would like to see a continuance with the board waiting for a review from the hydrologist on the property for the aquifer protection area. And I would feel more comfortable after the fact that we have a chance to be able to review it, to look at it and see if meets our standards. It meets the standards of what the state would be.
Okay.
That's how I feel. I'm not speaking for the rest of the board.
Yeah, I don't understand it's a rehearing. We don't need to go over the whole case. We can get into the semantics of what a rehearing is, but bottom line is, these are the 5 criteria that the board, or 10 criteria the board had issue with. Let me give you some clear answers on those 5 or 10 concerns right now. Okay, that puts everyone at this board to ease. But all we're hearing is, well, that's not a rehearing. Well, the rehearing. You either have the answers or you don't. You either have the clarity or you don't. And as far as, this is a very dynamic area. There's nothing like it in town to this effect, where you have 16 homes on a separate septic, another 39 that are on a community in the aquifer district, and then you're adding 2 more. So it only behooves us to do this right way once. And a hydrologist report, person vetted out by the town, it's either a thumbs up or a thumbs down. And as Paul Manzioni stated, I mean, that gives us all the clarity we need.
And I agree with that. If it's a thumbs up, then we are all set. If it's a thumbs down, so that goes back to, if, as you said, that it's a yes or a no. So that's why I'm asking for the contingency based on that aspect of it.
I personally think it's too dynamic of an area to just, this isn't a single-family home that we're questionable, is it too close to the waterfront or not? We can make fair assumptions on something like that. This is affecting the community. I think it needs a very comprehensive study by a hydrologist. And I'd feel a lot more comfortable knowing that result before I weighed in on continuing or given some sort of a contingency.
I would just feel more comfortable myself. And it's been a concern of mine right from the beginning.
Could I take 2 more minutes?
Sure.
Yep.
I think it achieves the same result that we're suggesting.
So, I know, at this point now, we just say, no,
hey, hold your ground.
Yeah, well, you know, we're gonna
Hold your ground.
move on.
If, if, if they don't, they wanna go further, then let's go further. Special exception doesn't make it. Anybody else is like that?
So we would be willing to make it a continuance coming back, but the concern is that, again, it seems like the one issue now is the hydrologist report, and that's what we spent most of the night talking about. If, you know, we come back in a month and it turns into a different issue that comes up. So that's why we were asking for the contingency, and that is the main concern. So I would just ask on the record now, is the one issue that we would be coming back with and discussing is the hydrologist report? Or is, you know, is it going to be a new issue that comes up the next time and this becomes something else?
Can I ask, have you presented everything you want to present on the record this evening with regard to all the other remaining issues?
And I think I've touched on all the hardship elements of the variance. I think I've discussed everything. But again, that leads to my question is if you say, you know, you meet this element for the hydrologist, but you haven't met this one, that's just something I would like to parse out tonight to make sure that my client's not going to go spend tens of thousands on
Right.
a report. And then we come back and you say, oh, you didn't meet the hardship element on the variance. So that's what I'm just trying to get
Here's
clarification.
the thing, though. Based on your representation as to what a new hearing entails, we would have to go through the worksheets for special exception and the variances that you're requesting and make a determination on all of those this evening. And if we reach a conclusion after going through those, that we would agree to approve them all on the condition that, and that would be the condition that you're asking. So for us to do that, you are going to require us to make a ruling and an ultimate decision this evening. Maybe the condition's in there, maybe it isn't. Maybe it's approved, maybe it's denied. This way, if we continue it, you get the hydrology report, then we go through all the criteria again. Either way, the criteria all have to be addressed before there's an ultimate decision in light of the fact that we're starting from scratch and we have to go through all the criteria. So I don't see how we leave this hearing tonight with an approval on all of these things conditioned on the one criterion of getting the hydrologist report, unless you ask us to do public input, do the whole hearing, go through all the criteria and make a decision. So whereas with a continuance, we get the hydrology report and you get to address the criteria unless you've addressed them all this evening. So, but the way I see it procedurally is those are only two options. I don't know how we say to you, it's all granted, conditioned on one thing, unless we go through all of the criteria for each of the variances and the special exception and come to that conclusion ourselves.
And I agree with that, and that's
Okay.
why I'm asking for some sort of assurance that what we're talking about at the next hearing is the hydrologist. So as again, if my client goes out and does the hydrologist report and then it comes back that the board determines hardship wasn't met, and that money was spent for nothing. So that's the issue here.
Right, I get it.
Which is a valid point.
Yeah. I just don't know how
Right
we
now,
get
we're
to
talking about the special exception. That's what the continuance would actually entail.
Well, I've
is
answered
the special
questions on it.
exception.
We've mixed them, kind of mixed them together at this point, so.
Not really.
Well,
That actually might be a good way to do this, is to, well, no, you don't want to have to come back on the other things. I just don't see how we get you an approval conditioned on the hydrologist without going through all of these applications individually and going through the worksheets and making a determination. And I don't know how people are going to be able to vote favorably to the applicant on certain of the criteria where the chief concern about the health of the aquifer is yet to be determined. So that's, like I could say, oh, it's safe, adequate supply of water and sewerage will be met. And one of the criterion of the special exception, I say, well, provided the hydrology report says that it is. And then there may be other things, diminution of value to other property. Well, provided that the aquifer is not going to be a problem. So many of the criteria depend on that issue. I think that's what gave the board trouble in the first place, and you got all denials. It's the way to do it right, in my opinion, is to let the board not make a decision, let the board get the hydrology report and see how that impacts all of the criteria that you need to satisfy in order to get approvals on all of these things.
But I think it all goes back to as Mr. Chair said, thumbs up or thumbs down. If the report comes back and it says that there's an issue with this additional system, then we can't go forward anyways. So all those other issues, so I think you can look at it and say, if, everything is good barring this one condition, the property values won't be diminished. And if, it goes the other way, which we don't think it will, then those issues become moot anyways, because there's no,
I
we
don't
won't be able to.
I don't think we can make that representation. Too many moving parts here. We'll have to get the report and see how it all fits together.
The special exception is first. But we have to move forward with the special exception before we go through the variance.
But again, the one issue that I'm hearing is this hydrologist report. And if it comes back good, then and if it comes back that we're all set, then every other element, it sounds like we've met. And please correct me if I'm wrong, because that's what we're trying to parse out here, that if you come back and say element 7 isn't met and it has nothing to do with the hydrologist report, then we're kind of spinning our wheels here and wasting our time and wasting your time for that matter.
Well,
So,
in the previous hearing, there was many items that were voted down. So if you want to take that roll of the dice, we can go forward tonight and go through the worksheets, public input, et cetera. Special exception may be denied, never even mind to the hydrologist, because there were other concerns. But we can work through that, but we can't give you a guarantee carte blanche. We have to walk through the process. We have to adjudicate this properly, right?
and that's
And
what
so then we get through the special exception. It may be denied on the face of it right there because 2 or 3 other issues will come up. I can't predict the future of that. They can't predict. I don't know how they would vote.
But we're all here now, and you could make a decision on those now.
If you want to go forward, we can, and then you'll have to roll the dice. It could be denied. It could be approved with a contingency, but we can't give you carte blanche. Hey, if you do this, we'll give you a thought. That's almost like a quid pro quo. If you give us that, you're going to get an approval.
That's not a quid pro quo, no. And the issue, what I'm asking for is just some sort of assurance that if I direct my client to go and get a hydrologist report, that that's the issue you're looking for. And if you're saying that there are other reasons you're going to deny this, then we would like to know.
Yeah,
That's
let
all we're
know
trying.
them now.
Yes.
I see what you're saying.
And
I
it's
agree with you.
literally going to be tens of thousands of dollars for this. And we've, provided the DES reports. If that's not what you're looking for, we thought it was satisfactory. And we're just, again, I'm trying to just work through this, and I'm not trying to make this a contentious battle. And I hope it's not coming off that way. I just want to make sure my client's being directed properly.
Let me ask you this. The board isn't required to get a hydrologist. We may get a hydrologist.
Yes.
Okay. So let's say the board just says, fine, you didn't bring a hydrologist. We're not going to get one, and we'll just rule on it all tonight based as it is. Okay? Do you think a court would do anything with that decision if the board took the information before it and said it was really important to us to understand what's going on with the aquifer? It's part of our zoning ordinance for special exception. We can't say that it's fine right now. There's nothing compels us legally to get a hydrologist. So we could decide to just go forward on the record as it exists right now, or we could continue it and give the applicant an opportunity to to have the board get a hydrologist and then go through it. You're asking us to decide everything in favor of the applicant, conditioned on the hydrology report. And I think that's asking too much.
I can't speak to what a court would do. I'm not going to
What are
comment.
our options? We
Again,
don't have a hydrology report here, so if we make decisions this evening, we do it without a hydrology report, and I don't think anybody would ever fault the board for making a decision without a hydrology report. Otherwise, we can continue it until we get a report.
there are certain questions on this that can be answered without a hydrology report, and that's what I'm trying to get some guidance on. And then the ones that you feel need a hydrologist report, you can make them contingent on getting that info. And so, I mean, no valid objection from abutters, stuff like that can be decided. Adequate and appropriate facilities and utilities will be provided to ensure the proper operation of the proposed use or structure. There's certain aspects of that question that can be answered now, and you could put pending hydrologist review. That's all we're trying to figure out, is if the board, based on what was presented, besides the hydrologist report, would approve this application.
Again, we'd have to go through the hearing. I don't know what the public input is. I don't know what an abutter is going to be saying come forward in opposition or in favor of this. That certainly weighs on our decisions all the time.
Well, we're here now, so
That's right. So if you want to go forward with the hearing, we can. But you're taking that risk of it could be denied. But we can't walk through every worksheet and say, okay, make a note, that's a hydrology question, that's a hydrology question. Yeah, you guys good to go, just bring that hydrologist report. That's not how it works. That's not the process of the zoning board. And everybody who stands before us as an applicant has to go through the same process. The previous case had to sit here, and then here I go, this is my case, and we work through it. And we honestly work very hard to accommodate every applicant. We have a track record of that. And in some cases, it doesn't work out, but they take a shot, and that's the way it falls.
Okay, well, I've presented what our position is, and
Yeah.
it's the board's decision.
I think we're kind of at loggerheads here. I mean,
So-
you're at that point now where you want us to try to vote on it and go through it. The chances are good that it's not going to pass. I think the advice of coming back and doing a continuance is probably your best advice at the moment. It's tough of a pill as it is to swallow.
Yeah.
Well, let me address that. You should have.
It doesn't need to be addressed.
No, I'm saying for the record. No, let me just say for the record.
That's
And
gonna be
you can come up and put your name on the record and be part of this if you want to do it instead of the back row. But let me just say this, as far as we're concerned for the board, you have every opportunity this evening, even though I take a different viewpoint on what a rehearing entails. I'm not saying you're restricted whatsoever. You have every opportunity tonight to address all the issues that you wish to address this evening in the rehearing. There's nobody on the board who's going to stop you from raising any issue this evening. Yeah. Yeah.
It's de novo. We started, so your discussion about you're only supposed to point out things that were different or illegal or unreasonable is legally incorrect. And I was trying to address that.
And that's what I just said. Yeah. Right.
Issue with him. He doesn't want to be dangled alone yet again. And what is clear tonight is that if we provide whatever report you think you need, we will be back on a variance. And you will deny that. So we are clear. You have all the information you need. Deny the special exception, deny the variance, do whatever you need. Mr. Dunphy is prepared to address all the questions regarding the remaining period. If you don't want to hear it, please tell us so that we're not wasting the audience's time, and go right ahead and deny. As you know, we have to file this request for rehearing, which we did. You granted it. We're here. We're here to address it. If you deny it, we go to the Superior Court or the Board of the HAP, the Housing Appeals Board. Those two bodies have the ability to reverse you entirely and say he should go forward, or send it back for yet another opportunity. It's clear that this board has come to its conclusion. It's time to conclude. So vote. Do what you need to do. Mr. Borowski will not do anything other than provide you a hydrology report as a condition of approval, so that we are not back here told again that there's another reason to deny. Mr. Dunphy has already explained to you why. It's thousands of dollars. So send him out to spend that money. He comes back with a report, your comment. The report says thumbs up. Great. And you folks decide that there's a hardship and he's denied anything. That's unfair to him, and we are not going to condone it. So it's time. Do what you need to do.
So the record's clear, though. It's very important that there's a clear record, because you misunderstood me entirely. Let me just finish. No, let me just finish. Let me just finish. You misunderstood me because let me finish. I made it very clear that you have every issue to raise tonight. We will not in any way restrict you to what my description of a hearing is on rehearing. That was simply my interpretation, my opinion. This applicant is not being restricted in any way whatsoever. So you can raise the whole case again. Okay.
What I'm hearing from you is you would prefer to kick the can down the road and give him a continuance. To be clear, he doesn't want it. It's time to vote.
That's fine.
Okay, so if I hear it correctly, you'd like to proceed?
Yes.
Okay.
Yes.
Anything else you'd like to add?
At this point, I do not.
Anything else from the board? All right, at that, I'll open it
May
up.
I just find out,
Yeah.
are we just doing special exception right now? Okay, and you have nothing else you want to add on special exception?
Correct.
Okay.
At this point, I'll open it up to public input. If anybody in the public would like to come forward in favor of this project, please come forward. That'd be no. And if anybody in the public is in opposition, if you'd like to come forward in opposition to this proposal. And that would be a no. So at this point, I'll close it to any public input. So we'll go to the special exception worksheet. I'll start it off with acceptance. A plat has been submitted in accordance with the appropriate criteria in Article 500, Section 520B. Yes.
Tim Morgan, and I agree.
Excuse me, agree.
I agree.
The
specific site is not an appropriate location for this use. I don't see it as appropriate for the aquifer protection area and having a hydrologist report.
I agree that it's not an appropriate location. We're concerned about the aquifer, and this is being cited on the aquifer.
I would agree that the only way we can determine if it is an appropriate location for the use would be with the benefit of a hydrologist's report, which the applicant has denied to provide.
I agree for the reasons stated by these two gentlemen.
I agree as well.
Factual evidence is not found that property value in the district will be reduced due to incompatible land uses. There was no testimony with respect to property values, and the land use around it is already used for the purpose for which this is intended. So it is not found that property value will be reduced.
I'll agree with that. We didn't, nothing was presented that would demonstrate currently that property values would be reduced.
I agree.
I agree.
I agree, there was no evidence.
There's no valid objection from abutters based on demonstrable fact. We heard no objection from any abutters, either in person or in any other way this evening.
I agree.
Agree?
I agree that there was no valid objection.
A nuisance, there is no undue nuisance or serious hazard to pedestrian or vehicular traffic, including the location design of access ways and off-street parking.
I agree.
Agree?
I agree that there is no undue nuisance.
I agree. Nothing about this is going to in any way impede pedestrian or vehicular traffic or create an undue nuisance for those.
Adequate and appropriate facilities and utilities will not be provided to ensure the proper operation of the proposed use of the structure. I can't comfortably say that the appropriate facilities and utilities are going to be adequate when I don't have the appropriate report in front of me saying that the facilities will be functional.
I agree.
I agree that they will not be provided.
I agree.
I agree.
There is not adequate area for safe and sanitary sewage disposal and water supply. This has been undetermined whether the area is safe for the aquifer protection area with added sewage.
I agree that there is not adequate area for safe and sanitary sewage disposal.
I agree based on the information we've been provided.
I agree.
I agree as well.
Proposed use or structure is consistent with the spirit of this ordinance and the intent of the master plan. One of the things that the master plan encourages is housing, which is of reasonable cost, and an expansion of the housing in Alton. So I think the proposed use is consistent with that.
I agree. I think this is otherwise a good application for a good purpose. It's just we need to be able to determine an important issue regarding the aquifer. So I agree that the proposed use is consistent with the spirit of the ordinance and the intent of the master plan.
I agree.
I agree.
I agree for the same reasons.
Right. Just a tabulation as far as the 8 criteria concerned. It failed unanimously on the appropriateness, and it failed unanimously on facilities, and it failed unanimously on sewage. We have a motion.
I move that we deny the special exception request to Article 600, Section 602C3 for case C2515.
And
I'll second.
all in favor?
Aye.
Aye. Special exception has been denied.
Just procedurally, since the special exception has been denied, do we need to reach the variances?
I would ask that you do so they can all go up together. We need some sort of decision.
So now we can move forward with that.
Yeah, I don't know. If you don't get the special exception, the variances don't even come into play.
If that's your position, and I need something to go appeal, so I need a decision.
So may I ask, on the first variance, the request under Article 400, Section 452.8.1 to permit 57 manufactured housing where only 28 are allowed. Have you presented everything this evening that you want to present on that variance application?
Yes, in response to Member Morgan's question about the variance during the special exception, I would incorporate that answer in. I discussed the 5 elements, the hardships, specifically the substantial justice. I will just add that there is no diminution of surrounding property values. I touched on the public policy, the master plan. So I believe I have touched on everything that I would like in the record.
Okay, thank you. Should we deal with them separately, like do a worksheet on this one?
Yeah, we can walk through that. We can walk through the variance worksheet. No other questions, no other comments from the applicant? Board's good?
Do we need to open it to
With
the
public
public?
input.
Yeah, I'll open it up to the public. Is there anybody in the public that would like to come forward in favor of this variance, which is looking to permit 57 manufacturing housing units in a park where only 28 are allowed per the rural zone density restrictions? Anybody in favor? Okay. Is there anybody in the public that is in opposition? That would be a no. So at this point, I'll close it to any public hearing. Public input, and we'll go to the variance worksheet. This variance will not be contrary to the public interest.
I agree.
I think it will be contrary to the public interest. The public interest here is density, and the request is to permit 57 units in an area where the density would limit it to 28. So I think that's contrary to the public interest.
I'm going to say will not be, from the standpoint that there are 55 there now that were permitted, and when it changed, the density changed, it made it, it reduced it to 28, but the request is only for 2 additional, so I will say will not be contrary.
I will agree that it will not, just for the same reasons this, we're adding 2, and one of them is outside the main road there, so I will say it will not be contrary to public interest.
Okay.
The request is in harmony with the spirit of the zoning ordinance and the intent of the master plan with the convenience, health, safety, and character of the district within which it is proposed. I'm sorry, I say is not in harmony with the request of the spirit of the zoning ordinance. for the safety and character of this area with the aquifer protection area.
I agree that it's not in harmony because it's health and safety of the district within which it's proposed.
I would say without the information regarding the aquifer, that it is not, it is not in harmony with the spirit of the zoning ordinance intent in the master plan and the convenience, health, and safety and character of the district.
I will say it is not for the same reason having to do with the,
Same, I do not believe it's in harmony.
By granting the variance, substantial justice will not be done. The risk to the public of having this potential danger to the aquifer far outweighs any benefit to the applicant.
Yeah, I'm going to agree with that, especially in light of the denial of the special exception.
granting the variances, substantial justice will. By granting the variance, substantial justice will not be done. Oh, I'm struggling with this one. Give me 1 second. Yeah, by granting the variance, substantial justice will not be done.
Okay, I agree.
I agree.
Me?
Yes.
The request will not diminish the value of the surrounding properties, at least the information we have currently does not show that there would be any diminution of value of surrounding properties.
I agree.
I agree.
I agree as well.
I agree it will not diminish the value of surrounding properties.
A hardship. For the purposes of this subparagraph, unnecessary hardship means that owing to special conditions of the property that distinguish it from other properties of the area. Number 1, no fair and substantial relationship exists between the general public purposes of the ordinance provision in the specific application and that provision to the property. I would say yes. And the proposed use is a reasonable one. I'm going to say no. Because we're over, and I say no because because the addition of the units, crowding.
I would agree on 1, yes, and no on 2.
I agree as well.
I think there is a substantial relationship. I think it is in violation of a substantial relationship between the general public purposes of the ordinance. I think the purposes of the ordinance are to protect the public in this instance, and this does not accomplish it. And I also agree that the proposed use is not reasonable.
I would disagree. I think that on the density issue alone, that given what's out there already with the 55 units, and this is only for an additional 2, and for the purpose of providing housing and so forth, that no fair and substantial relationship exists between the general purpose of the ordinance, that being density, and given what's already there, and then the proposed use is reasonable. I would say yes to that because it's residential, which is what's been going on there anyway. So solely on the issue of the density, I think they meet that.
Okay, for the 5 criteria, It was 4-1 in favor on public interest. It was unanimously denied on the spirit of the ordinance. It was unanimously denied on substantial justice. It was unanimously approved on the values of the surrounding properties. And as far as hardship, for first portion one, it was 4-1 in favor. And then the second portion, it was 4-1 against.
Mr. Chairman, I make a motion that we deny the variance request for Article 400, Section 452A1 to permit 57 units in an area where only 28 units are permitted in KC 2515.
I second.
All in favor?
Aye.
Aye.
Aye. Okay. And the last one, a variance is requested for Article 300, Section 350C2C to permit a new manufactured home to be 3 feet or 3.9 feet within the 30 feet interior park setback. Is there anything else you'd like to add to that?
Just specifically on this variance, it's, as you said, for setback relief, it's a modest increase into the setback of 3.9 feet. If you look at the surrounding area, this community in general, a lot of the houses within Eagles Rest have this similar type of setbacks, and it's all dispersed throughout. This one is a pretty minor request. It's not going to impact the health, safety, or welfare. It will not impact road frontage or road sightage. I mean, people can still see. No concerns about overcrowding because it matches the same type of character of the neighborhood that's there now. It's in harmony with the spirit of the ordinance and master plan for those same reasons. And I will say it's a private road, so there's no impact on public services because of this setback relief. And the substantial justice will be done because it would allow, although we've already been denied on the actual unit itself, it would have allowed for this additional unit to be built for potential future residents of Alton who could have enjoyed this type of housing. And it would have allowed Mr. Borowski to modestly increase the density of his house without impacting the community. There'll be no diminution in surrounding property values because it is an interior lot. It's not near the boundaries and it matches the existing criteria. For the hardship, no fair and substantial justice relationship, they're, owing to special conditions of the property that distinguish it from others in the area, denial of the variance would result in the necessary hardship. As I've said, this property is unique in its layout and in its history. I'll incorporate what I said before. No fair and substantial relationship exists between the general public purposes of the ordinance and the specific application to the property. Again, this property is unique. It's the zoning ordinance was amended after this whole community was created. So there's no direct relationship between the current ordinance and what we're requesting here. And the proposed use is a reasonable one. Again, unfortunately, it got kind of lost tonight, but this is about 2 houses. It's about helping with the housing crisis. It's about adding additional housing in this community, and it matches the existing criteria of this neighborhood. It could have been a great place for somebody to live, but again, that's why this variance should be denied. I mean, approved, although the others were denied. Thanks.
Okay, thank you.
Could I just ask a point of order? Number 3 variance has been withdrawn because it's essentially a duplicate of one already.
That is the one Ms. Dietrich addressed in the beginning, I believe. And she can correct me if I'm wrong,
Yes.
that it was a duplicate and we were all in agreement and it was officially taken off. So,
Okay, good. I just wanted to
yes.
make sure. Thank you.
And Mr. Chairman,
Yes.
I just can't help but question what this variance gives us, or why is this variance not just either withdrawn or, because it doesn't really apply at this point. If the housing unit number cannot be, you can't add 2 more units, then where one of them is sitting on a lot doesn't really make sense.
I think the applicant for the rehearing is planning to appeal the decisions of this board, so they'll want something to appeal.
And
That's why
I
you
want to
go
make
to
sure
it.
we get them all covered. So again, the same issue that was discussed earlier, we don't come back here if we get to that point. I would rather it all be addressed tonight so we can keep them as a package.
I think that's a reasonable request.
Okay. With that, I'll open the hearing to any public input of anybody in the public who is in favor of this proposal. Okay, that'd be a no. And is there anybody in the public that is in opposition to this proposal? Come forward. That'd be no. All right, we'll get to the worksheet then. The variance will not be contrary to the public interest. I think this variance, if it was approved, I think this would tie right in with the rest of the community.
I agree as well for the same reason.
I agree.
I agree, and I would add, I thought this was all a good application to just add the two structures. It would have been a good application, it just needed more information.
I agree.
It's up to you. Yeah.
Spirit of the ordinance for the Article 300, Section 350B2 is in harmony with the spirit of the zoning ordinance and the intent of the master plan and with the convenience, health, safety, and character of the district within which it is proposed for the setback for the specific manufactured home.
Right, we're just addressing the setback here, and I think that's in harmony with the spirit of the ordinance.
Yeah, I agree also, this 3.9 feet on this setback should not be a problem.
I agree.
I agree.
By granting the variance, substantial justice will be done. The benefit to the applicant to have this setback variance outweighs any diminishing value to the people of town.
I agree, substantial justice will be done in this community of homes. It's beneficial, and that's a minor request on that setback.
I agree.
I agree.
Agree?
The request will not diminish the value of surrounding properties. We have no evidence of any kind that it would, and I couldn't imagine that a small thing like this in the setback would have any adverse effect.
I agree.
I agree.
Agreed. I agree as well.
Okay, for hardship, no, the purposes of this subparagraph, unnecessary hardship means that owing to special conditions of the property that distinguish it from other properties in the area. Number one, no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property. Is I say yes. And for two, the proposed use is a reasonable one. I say yes.
I agree on both.
I agree as well for the same reason.
I do as well. I agree.
I agree as well on both use and hardship. Matt?
Okay, just to reiterate, it was unanimously passed on all five criteria as far as the variance for Article 300, Section 350C to C.
Chairman, I move that we grant the variance from Article 300, Section 350B2, permit the home to be with 3.9 feet within the setback for application C-4515.
I'll second that motion.
All in favor?
Aye.
Thank
Thanks,
you
sir.
very much.
Thank you.
You guys want a break? All right, we're going to take a quick 5-minute recess. Recess there. 5 minutes.
Say it once.
if they take it a continuance, came back with the report, everything we denied was based on the issue of the aquifer. So, and it, you know, it,
I take a 1 minute break, please.
yeah, we're taking 5 minutes, so you got 4 extra minutes. Yeah. Maybe I'll take advantage of this opportunity. No, there's a motorcycle. No, recently, I thought so. He's doing it. What's mine? You guys are number 2?
motorcycle guy?
Huh?
What do you ride for motorcycle?
Road glide.
Oh, you get a road glide?
Yeah.
Across the street. That's the Eagles nest.
Yeah.
It's it probably came out of
What's happened? That was the guy that was their client back.
No,
No, that wasn't Frosty.
no, I don't, no, this guy. Is that Pulaski?
Yeah, because there was a younger. Who was a good before. Yeah, it's that guy.
Yeah, it's only where he went, just
Can't
past
be
the.
talking about. Spending that CPA.
Becoming more nice.
Oh, yeah.
You work in the morning?
Yeah, but I worked from home in the beginning for the first time of the day, and
Yeah.
I did it a lot. Okay, page 22.
Okay, we're going to resume the next case, which is KZ 25-22. Jeremiah Vandernoot and Jillian Cody, agents for Christine and Joseph Perella, owners, map 25, lots 33 and 31, Baxter Place Road. It's a variance in the rural zone. The variance is requested from Article 400, Section 452A1, to allow a non-conforming lot of 1.0 acres due to subsequent lot line adjustment where lots under 2 acres are not permitted.
Hi, good evening.
Your names, please?
My name is Jeremiah Vandernoot.
Okay, welcome. Just give us a minute. We'll look over the application.
Mr. Chairman, I'll move that we accept application Z 25-22 as complete.
And we got a second?
I'll second.
All in favor? Aye.
Aye.
Okay, welcome, Jeremiah and Jillian. Would like to tell us about your variance you're requesting.
Yeah, so we currently own a 0.9 acre lot, Frank Way. Our neighbors are actually here tonight. Christina and Joe Perella have agreed to sell us 0.38 acres, which is part of their larger plot. It's just adjacent to our lot. We're just looking to purchase that, do a boundary line adjustment to basically double the size of our lot, give ourselves a little bit of setback relief in the event, probably the next 3 to 5 years, look at building a garage. We just currently don't have the setback. So that'll, alleviate just have to come back here and request that. While of course increasing, the value of our property as well. So I think it's pretty straightforward there. Just cut that piece off of theirs and attach it to ours. Yeah, but that lot would be less than 2 acres, which would be the variance request. It would be not conforming to the 2 acre requirement.
Mr. Chairman, may I?
Yep.
The current lot is 0.29 acres.
Correct.
And I gather, is it correct that lot was created then obviously before there was zoning?
Correct. From our knowledge, around 2005.
There was zoning in 2005.
But we had not owned it that long. We bought it
Right.
last January.
There's a structure on the lot?
There is our house.
Your house is on the lot, and the lot is only 0.29 acres.
Correct.
You want to buy some additional land to extend the lot so it'll be 0.67 acres.
Correct.
And that's still too small. If you're creating a new lot, it doesn't meet the minimum square footage requirement for a residential lot.
Yes.
Right. Just wondering how it was 2.29 in the first place, but it was like that when you bought it.
Correct, yeah,
No.
we'll go 18 months.
Hmm.
Just moving in the direction while something's available.
Right, we're trying to become more, more.
Can you help us a little bit with this?
Absolutely.
This is the lot that you're currently on.
Yeah, so that bold line, we own basically the bottom half of that. There's a
And the piece that's above it is currently part of this big lot,
correct.
and it's on the other side of the road from the big piece.
Yes. So there's a private road that
That's
moves
what's
on the
listed as
Franklin
Franklin Way.
correct. Yes.
So this is second to the last property on front.
Yes, we are second to left property.
Say current. The one that dips. Basically, this dead ends right there.
Yes.
Sure. Abutting property, turn around right there. Go back out.
Correct. Yep.
Is that wetlands or anything in between Baxter Place and Franklin Way?
No. No, we have the Merrimack Marsh behind our house. Yes.
Okay, Mark, right, I see.
So they're contiguous. They abut each other.
Where do you see back?
Right. Nothing in between. They-
No.
Right,
No.
That's why we want to, so it's just.
right, one big lot.
Right.
Right.
Oh, okay.
You could buy it and own both without creating a new lot, right?
We could what, sorry?
You could buy it and you would own both without creating a new lot, and you would still effectively have
Correct.
the
Yeah.
use and,
Either way would be a non-conforming lot. It would be less than 2 acres. So
yeah, but if you just bought it,
But
it,
we have to, it, we have to take it from them, because they have the big lot.
yeah, but it exists already as a lot in the town. So
Correct.
it must be a legal lot if it exists, and yours is a legal lot. It exists. I'm not sure how, by the way, but we can deal with that later. This is maybe a subdivision that was created, or these lots were created before there was zoning.
Right.
So going back even into the 60s would have been, and if you bought the other lot and just owned it, you wouldn't have to create a new lot,
correct.
and you wouldn't need to be here. But, and the only reason you're here is because you're going to create one lot out of the two. And you're creating a brand-new lot, and that brand-new lot does not comply with zoning. The other lots, I guess, are grandfathered, so you don't have an issue with them.
Right, but even if we were to just cut that lot off and buy, it would only be 0.38 acres, would still be less than 2 acres, we'd still require variance.
I think that's what I was asking him. I think this is currently part of this lot. Being cut off.
Oh.
Yes.
Oh,
That's what I was trying to make.
I'm sorry. Oh, okay.
Just that.
Oh, well, thank you for that clarification. So,
Like 17.
okay, yeah, that, I see that one little piece.
Yes.
Okay, I get it. So, yeah, but, okay, I gotcha. Because the new lot you're creating isn't taking the two lots. Anyway, I got it. Right. And of course, the lot that will be remaining if, after you acquire that land is a big lot. So you're not going to create a non-conforming lot with that lot. That's a,
Big lot is 16 plus acres.
yeah,
so
okay,
You just take a little piece off that.
yeah.
Is that the only piece on that whole lot that juts out like that?
There's a few little spots, but that's the one that's adjacent to our lot, so that's who we're looking at.
You don't know when your lot was created?
And our house was built in 2005. I can't say when it was actually.
Wow, the house was built in 2005 on a 0.29 acre lot?
That's all I know. Correct.
It's Franklin Way, actually, off Franklin Way, off of Baxter Place.
Right.
Those were created a long time ago. predate zoning? Oh, okay. Makes sense.
Yeah, but if the house was built in 2005, even though the lot was created
Could have been replacing.
before zoning,
But it could have been, in 75, it could have been replacing a house, something else that was there, some camp or something.
they still would have needed a special exception.
Right.
That's, well, maybe we'll get public input on that. It's interesting to me that a house was built in 2005 on a 0.29 acre
Right.
lot in a zone that probably needs 2 acres for it to be a buildable lot. And
And we didn't build a house.
So.
no, I know that. No, I'm not saying that. I'm not saying that. I don't know about that.
Yes, to do.
I don't know about that. You could buy a non-buildable lot, and you're stuck with it. You can't put a house on a non-buildable lot. But you bought it, the house was on it, just,
Saying to make it a more conforming.
Correct.
Else with it, it's making it
right,
more.
less non-conforming.
Less non-conforming.
Hmm.
This is showing that was on the properties like these.
Yeah.
Lots of properties upstairs, there's no upstairs there. Those lots.
Hmm.
Have more than 200 feet of frontage.
Yes, according to the survey.
That's the best tax bill in town.
I agree.
Any other questions from the board?
You're gonna go to the planning board after this if you get
Correct.
approval?
Yes, that's next step. We'll have NORAD Plains represent us for that.
Excuse me?
We'll have NORAD Plains represent us for that survey, yeah.
Okay. All right, well, if we're good, I'll open it up at this point to any public input. If anybody who is in favor of this proposal, come forward. No? Is there anybody who is in opposition in the public that would like to come forward? That's a no, so we'll close it to public input, and we can get right to the worksheet.
Variance worksheet.
This variance will not be contrary to the public interest.
I agree.
Agreed.
The request is in harmony with the spirit of the zoning ordinance, the intent of the master plan, and the convenience, health, safety, and character of the district within which it's proposed. They're making a non-conforming lot, making it less non-conforming.
Agree.
I agree.
Agreed.
Agree.
By granting the variance, substantial justice will be done. The benefit to the applicant outweighs any detriment to the people of the town of Alton.
I agree.
I agree.
I agree.
I agree as well.
The request will not diminish the value of surrounding properties. We have no evidence presented to us on that, and there's nothing in the record or in the application that would indicate that there'd be a diminishment of surrounding properties.
I agree.
I agree.
Agree.
I agree.
Hardship, no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application to the provision to the properties. That's a yes. And number two, the proposed use is a reasonable one. That is a yes.
I agree on both.
Yes, I agree.
I agree on both.
I agree on both as well.
Okay. We have a motion. It's unanimous. All 5 criteria pass.
Mr. Chairman, I make a motion that we grant the variance from Article 400, Section 452A1 to create a new lot in application C2522.
I'll second that motion.
All in favor?
Aye.
Nice job, you're all set. That was easy.
Easy brain.
I wish they were. I wish they were all that easy. Yeah, exactly. I wish they were all that easy.
You know. Nice, huh? Okay, our next case is Z2523, Vonnie Engineering, Tom Vonnie, agent for Roger and Catherine La Rochelle, map 38, lot 5514, 4 Grammys Way, special exception in the Lakeshore Residential Zone. A special exception is requested from Article 300, Section 320D3E to allow the expansion of an existing building of more than 10% of the gross floor value. Welcome. Your name, sir?
How you doing?
Your name?
Roger Larich.
Yeah, hey, Tom, how are you?
Engineer.
How you doing?
And for the record, just like to state, Mr. LaRochelle, we're not related in any way. I'm sorry. Nice to meet you. Nobody that I know of in my family, Roger LaRochelle.
We went through that. Did you one other time before?
Okay. Let's look over the application.
It may require additional proof. I'm just not.
Yeah, I know. Same.
I like airplanes. That's right.
So I have met you out on the ice.
And Tom, we've never seen before in our life.
Move to accept application Z25-23 is complete.
I'll second that.
All in favor?
Right.
Okay, Tom.
To, Josh Tebow is here, he helps me, he's drawn up to the plan and does a lot of this work. So Roger and Catherine LaRochelle purchased this unit number 4 of Lakeview, a condominium in 2017. They'd like to raise the existing cottage, install a foundation under the building. The installation of the foundation will result in an increase in the height of the building, approximately 5 feet. Cottage is connected to a state-approved septic system in 1997. There is no proposed increase in sewage loading. The entity shoreline permit is required for the construction of the foundation will be applied for after the zoning board approval. So this property is beyond Sandy Point. Drive along the lake. The lake is near the highway. You see land again. This is the condominium. There's a road, Grammys Way there. There's 4 units. He owns unit 4, which is a year-round building. And he'd like to put a foundation under that because there's a partial foundation with dirt, and Josh has figured out the grades, et cetera, and they'll sloping land, so it's not a big change. It's raising it up 5 feet to have a full foundation within the footprint. And on page 2, I have diagrams of the new building and the proposed that show you what it is that he's shown as far as building plans. So this building is in the building setback. So what we're asking for is a special exception to raise it up like we're doing, and also going down too. So that has been in the ordinance for a number of years, and it's been changed as of March. So we're still asking for a special exception for that. Mr. Varney, will the change in elevation affect anybody's view?
I don't believe so. It's down below the road level anyway.
Yeah. But it won't affect the other 3
I don't
cottages?
believe so. They're across the road a ways, and
Yeah, it's good elevation.
it wouldn't, I don't believe it would block your view at all.
I spoke to the people across the street from there, and they're all okay with it. Yes, him, I don't know his last name, and the other guy come over, he got a registered letter, and he just wanted to know, and I showed him exactly what I was doing. And he said, okay, just wanted to know. He was okay with it as well, and everybody in there is okay too, they signed off on it.
So in one of the pictures.
Yep.
He was taking the existing house and raising this foundation.
Yes.
Yeah.
It's dirt down there, very musty.
Yeah, we do. I see it happening.
My granddaughter
all over
is
the
out.
place. It's funny.
Every time she comes out, we have the problem.
Um, So, D3, E, it says, does not involve expansion of an existing building of more than 10% of the gross floor area of the existing building at the time the use became non-conforming. I didn't participate in writing that, okay? I helped change this thing years ago, but I'm just seeing this. What does that mean here? So,
If you read the new rules, it's kind of disturbing to me because those rules were there for 20 years and there was definition of what we're talking about. So a non-conforming building becomes more non-conforming.
Right.
A little obscure abstract thought involved in that, but in all the rules, you had a lot to read about it. You could place something there in the rules. Now that has been removed, that up or down, what we're talking about, for a structure, for a use has been removed, and the language which you just read comes out of who knows where, in a way, different, so,
I mean, when we were on Zach and we were doing the, amending the ordinances and stuff, we would, for years, if somebody had a non-conforming building, you know, and they wanted, it was dilapidated and they wanted to fix it, they couldn't because then it would take them out of grandfathering and all that. So then we rewrote this and said you can expand and you can redo it, take it down, rebuild it, stay within the footprint, make it less non-conforming if possible. And if you wanted to expand it up or whatever, you had to get a special exception. So you're doing all that now, and you're staying within the footprint. All you're doing is putting a foundation under it. But I don't know what, this is expansion of non-conforming use. And then E says, does not involve expansion of an existing building of more than 10% of the gross floor area of the existing building at the time the use became non-conforming. Not sure what that's talking about. So you're within the footprint, right?
yes.
Yeah. And I know in the narrative I read that the 800 square feet or whatever will be added, will double the square footage.
Yeah, it would be 50% increase, I believe.
Right, 50%, but not, that's a total square footage. So I don't know what it's doing to the floor area. If you're staying within the footprint, I would imagine you must be staying within the floor area.
Could be the case, yeah.
I don't know.
Yes.
But, all right, so I mean, I just wanted to clarify that. Yeah.
Yeah, we're not changing anything on the bill. They're just
Going out 5 feet.
Yeah.
Right.
And just put a foundation.
Jeff, it's 5 feet, it'd be a total of, I think, 23 feet. Is that a time that's all said and done?
Well, we can only, yeah, 25 feet. 25 feet.
Yeah, 25.
Yeah.
I'm just curious about all the department heads. Why are they all non-available for all the reviews?
they didn't respond or they said they didn't have any comments. So that just means that they didn't have any comments.
Okay, okay, other than instead of writing a comment. Because I saw not available, so I thought maybe.
Or not applicable, I guess.
Not
I know what you
applicable.
mean. Yeah.
Okay, thank you.
This was a difficult decision to figure out where this fit. So I like that you're questioning it a bit. And looking at what it says in the zoning ordinance that is new and different. Because Tom and I certainly had a little bit of a difficulty just to get to where we are now, so.
Tom, anything else?
The place has been upgraded, the walls on the lake have been improved, the wetland permit, the docks have been replaced with new docks. And, no issues with that at all. It's surely a move. Yeah.
Yeah, I see under the non-conforming uses on D2, and it says, non-conforming use may be changed to another non-conforming use provided the zoning board of adjustment grants special exceptions warranted because the change in use will be equally or more appropriate to the district and the neighborhood. And certainly this is an upgrade that would be more appropriate for the neighborhood. So I think it certainly fits into that, and it's better for the neighborhood in general, so. But I can see where there'd be some question. All right, anything else from the board? All right, at this point, I'll open it up to public input. Anybody out there in favor of this proposal, if you'd like to come forward? That'd be a no. And anybody in the public who is in opposition of this special exception? No. At this point, I'll close it to any public input, and we can move right to the worksheet. A plat has been submitted in accordance with the appropriate criteria in Article 500, Section 520B. Yes.
I agree.
Agreed.
The specific site is an appropriate location for the use. This is simply putting a new foundation, raising the property for a betterment of the owner for the property.
You agree?
The use is not changing, I agree.
I agree.
I agree.
Factual evidence is not found that property value in the district will be reduced due to incompatible land uses. There was no testimony about value, but it would seem that it would improve local values, if anything.
I agree that factual evidence is not found, and because it's not an incompatible land use.
I agree.
Agree.
Agreed.
There's no valid objection from the butters based on demonstrable fact. No one objected, and there are no facts in front of us that would show any basis for a valid objection.
I agree.
Agree.
I agree. Nuisance, there is no undue nuisance or serious hazard to pedestrian or vehicular traffic, including the location and design of access ways and off-street parking. It's a little small cul-de-sac, I guess, not even that. I know Graham's Way, I see it, yeah.
Okay, I agree.
Agree? I agree.
Yeah, I agree that nothing about this application is going to affect these things.
Adequate and appropriate facilities and utilities will be provided to ensure the proper operation of the proposed use or structure.
Agreed.
Agreed.
I agree.
I agree.
There is adequate area for safe and sanitary sewage disposal and water supply. It's approved by the state septic system. There's no increase in the loading, and this is simply, again, raising the property, no change or adding of any bedrooms.
I agree.
I agree.
Agreed.
Agree.
Proposed use or structure is consistent with this various ordinance, the intent of the master plan. It's improving an old cabin along the lake, and that's something good for the town.
I agree.
I agree also.
I agree.
Great.
All right. Mr. LaRochelle, you passed unanimously all the 8 criteria. If we could get a motion.
I move that we approve special exception requested to Article 300, Section 320D3 in application Z25-23.
I'll second that.
All in favor?
Aye.
Thank you very much.
Thank you.
Good luck. Thanks.
Okay, our next case, our last case is case Z25-24 Prospect Mountain Survey, agent for Stephen Grant, applicant for the T&M Fitzgerald Family Revocable Trust, owner. Map 9, Lot 57, New Durham Road, asking for a variance in the rural residential zone. Variance is requested from Article 400, Section 401D4 to allow a country store and a gas station. Welcome.
Before we begin on this one, I'm not really sure what to do. Maybe the safest thing is I just not do any, recuse myself. I live on this road. Yeah, and I don't know anything about it other than I skim through the materials. I don't know how, it would impact me, and I want to be fair and objective. I don't want to sit here and all of a sudden feel like this is going to impact me as a person on that road, and then I can't do my job correctly, so I probably should sit it out. Yeah.
I'm not
Okay.
opposing.
Yeah.
I met with the DOT and we've taken the access to the property out of the controlled access area to eliminate congestion as it comes around.
Right. Yeah. I mean, I just don't want there to be an issue. Like if all of a sudden I went the other way and people go, oh, you did that because you lived there and you were being personal, which I wouldn't be, but I think to be safe. Yeah, no, I think to be fair and to be safe, I should probably just be cautious.
Okay,
Yeah, thank you. I gotta recuse.
Say it again to me.
I'll stay at the end of the day, I'm not leaving. I'm gonna go home and eat something. No, I'm not even kidding.
All right, just give us a second to look over the application.
Do we need a quorum to vote?
What's that?
We still have full.
Yeah.
Chairman, I'm going to move that we accept application Z25-24 as complete.
Second.
All in favor? Aye.
Aye.
Okay, your names, please?
My name is Stephen Grant.
Hi, Stephen. And we know Paul.
You're on.
You're on.
Oh, thanks. Name's Paul Zusko. We're asking that a country store gas station be allowed in the, what's that zone?
All residential.
RR zone, which is not allowed. This lot been there forever, and I know I've seen probably 4 different surveyors surveying that lot in the last 10 years, probably. I know McDonald's tried to be there first, and I don't know why they didn't go there and move over. I wasn't around then. But anyway, your master plan states that this should have been, this was zoned commercial one time, I believe. And then they changed it. And since they changed it, no one's been able to even make an offer for a residential lot. It's in the traffic circle. Everything around it is commercial. This is probably the best thing for it. So we're asking that this business be allowed.
It's gonna be in the inside of the traffic circle?
It's gonna be across from the Huggins and McDonald's, that corner. New Durham Road.
Inside that circle.
Well, it's outside of the circle.
Yeah, go around Durham. It's inside it. We should.
Yeah, these properties been before on different times in the past, so I at least, and maybe some of the others are familiar. McDonald's didn't, because DOT wouldn't give them the driveway permit, they needed to.
Approached DOT, and they said where they would like the driveway. That's where we show it on the plan.
Yeah, it was also gonna be, if there was wetlands, you couldn't have parking.
A lot of things have changed since then. As far as wetlands, we can fill. If you want to see some wetlands filled, you should go to Epsom Traffic Circle and see that new gas station there. They filled quite a bit, but this one here is not a lot of wetlands being filled. Where I show the parking will probably be retaining walls, so you have the wetland and then a retaining wall, so there'd be no impact to it. All the drainage would be going to the other side of the lot.
If you do that much fill, will you have to do one of the state programs where you protect some wetlands somewhere else, or you'd be within the?
Do that anymore? No, they don't mitigate that anymore.
So you'd be all right to fill this, you'll get a DES permit or whatever's required now to fill it?
I know Hannaford had to do that when they filled in. They had to go buy some land and make it wetlands.
And this driveway that you show us, is that across from the driveway for Huggins?
Across from Huggins, yep.
Thank you.
So no access from 11.
No. No, correct.
Yeah.
Have you done any study?
No
traffic?
studies. No.
Traffic, because there's already residential in that area. Down the road, across the street is the care center.
Yep.
There's traffic there, that's McDonald's, it's gonna be quite an increase for retail and gasoline right there, coming into that section.
I'm sure we'd have to do a traffic study.
Mm-hmm.
I'm sure DOT is going to make them do something. And I'm sure the town engineer will look at it too. Well, if we get the site plan review.
Do you have like a plan of the building, what it's gonna look like? We haven't got there yet on that. We're shooting for, the approval for the change of the use in that zoning.
Right.
So it'd be allowed. No, we don't want to spend all that money and then not get.
Well, that's the big, it's not allowed.
Right.
You're asking for something that's not allowed.
No, but if you read your master plan, that's the direction they believe that.
Right, I was part of the master plan and creating the master plan, that's, we want to encourage businesses.
But I don't think anybody's building a residential home there either, period.
No, I get your point. Down the road, that zone may be changed down the road, and possibly things change in the format of the master plan of creating an area for more.
You guys would know, on the opposite side of the street, which is, I think it's just a rural zone, there's rumors of a liquor store and rumors of a like CVS or Walgreens drugstore going over there.
Yeah, they came before us, yeah.
They came before you guys?
Yeah.
And they're held up with the DOT right now. The gentleman that I met was out of Rochester, because they wanted to go into the controlled access. And
also wanted 2 entrances, which DOT said no.
Have a good sign, is that? Access.
Second gas station in Alton.
It's right across the street. Right here, isn't it?
Down
Oh,
here,
Village.
over here.
Oh,
The Village Circle,
Village.
Village.
I mean, you obviously feel it's a viable business, otherwise you feel it's a viable business, otherwise you wouldn't be pursuing it, but it just seems difficult for me to comprehend. I'm not coming off of 11 and shooting in to get my gas. I have to go up New Durham Road for a little bit and then turn into there, which to me, that seems inconvenient.
They do it for McDonald's.
Yeah,
Well, they do,
yeah.
but then again, it's not double the increase.
Absolutely.
And that's where,
Double and not triple.
and that's where the traffic study and DOT will make them could widen the road, more turning lanes, who knows?
This used to be zone commercial.
I believe it was. Paul would know that more.
Do you have a brand? Is there a few? You
Did McDonald's come in and get a special or a variance to try and build it there? It could have been zone commercial then.
They were gonna go right where you're talking.
Yeah.
At one point, they were denied.
Why were they
You can't
denied?
mention the,
Because it was not use.
well, because each brand
They
has
end up,
has
it's
style.
move over and instead of where they are.
Hackers has a style, Irving has style.
And that was some time ago, I don't know if you recall.
What's that rapid place?
I do.
Has style.
DOT was part of that, and problems with the driveway, they couldn't go in and out, do a drive-through thing.
So you're saying it's allowed now to fill that? You said without doing something tick for tack?
No mitigation anymore.
Mitigation?
No.
Seems crazy.
The state would regulate everything here, Paul. Being the sensitive area, the state does everything.
Being a gas station, they'd be really regulated.
Yeah.
Well, the designers would be Wilcox and Batten out of Concord. That's what they specialize in.
You might know their wetland scientist, Cindy.
So, are you gonna be doing automotive service?
Just gas station,
Just a gas.
country store, just like Circle Store.
service station, can that be a repair garage? Or, because they also have a automotive truck used, no, I'm sorry, automotive and truck repair garage. So service station would be limiting you just to selling it for sales of fuel. You can't do repairs if you're a service station. Okay.
There'd still be some sort of a buffer to the circle, or would there be signage to direct people, obviously,
There'd be,
to that New Durham Road?
Yes,
So
there's a
it's like
setback.
there isn't any access from Route 11.
there would have to be signage.
There would be signage, but there's also a buffer that the state probably won't let you touch. And it's typically 75 feet off center line of the highway, so that's gonna be continued around the circle. So there'll be foliage that will still protect that. I'm sure there'll be some clearances of, visuals of seeing the pumps in the buildings as you come in. I guess, what are we coming west? Coming west into the hall, right?
Yeah.
Yeah.
The proposed building, how big is it gonna be?
I remember.
1,600 square feet.
Yeah.
I believe it's around 1,600 square feet, 2,000 square feet.
How tall?
It'd be like the Irving Station in Farmington, right?
Similar, yes. I haven't seen Irving Station in Falmouth, but they're all pretty much.
I think it's Irving.
Yeah, I think it's Circle K, right?
Yeah, oh yeah, Circle K.
They're pretty much the same.
Yeah.
And it's just one entrance.
So,
Just one entrance?
It's all real loud.
split out.
Yeah.
Just a little vague on what the building size, concept, look, feel, what you're doing with just looking at what you're proposing.
Well, I have to run that right to the planning board, right?
Usually we see some sort of conceptual of what's gonna be there, other than just a look at what we're looking down in the parking lot. Are those supposed to be the gas tanks?
Yeah. Gas tanks in the front. Or on Leaven's side.
Okay. And the pumps themselves, where those cars are?
Yes.
You mean the underground tank?
Yeah, those are the underground
Yeah,
tanks.
these are the underground tanks here.
Cylinders there.
Yeah, and then these are the pumps.
Yeah.
Those are the pumps where
Yeah.
you're showing the cars.
Yeah, yeah.
So everybody's coming in the same direction, going back out the same.
Yeah.
Yeah, some of these new gas stations, they're actually like a restaurant, like a Common Man. There's the one over in
Epson has the common man one now.
yeah, and I mean, they're structuring themselves 2 to 3 stories high. It's a full dining service. This is more of the Circle K convenience store.
This is, it's not a Circle K, but
Right.
it's similar, yes.
Similar to that, convenient.
Potato chips, cookies, that.
Yes.
Sodas.
Breakfast sandwiches.
Breakfast sandwiches, you got a little kitchen?
Be like the Circle K in Farmington. Although they have a full kitchen and everything. It's gonna be more like the one in Farmington.
Okay.
The one down, the Irving?
Right there at the light.
Yeah,
Yeah.
Probably
Yes,
that one.
yep, yep, yeah,
Microwave,
Yeah.
what do you call those, heat
yep,
lamps and all that.
coffee.
Health food.
Mm-hmm. Gotta have coffee.
I think this is gonna be scrutinized quite a bit from the DOT, just because of what it is that you guys are accepted. Well, I don't accept it, but they're gonna, I'm sure that we have some strict requirements in everything you do. Alright.
This is for the office only.
Oh, yeah, yeah. I mean, underground tanks, and it's all virgin property, so, yeah.
It certainly would be a residential.
Right. Location's pretty good, though. I mean, right, that circle is wide enough, it's double lane. Really? And you're gonna find out why in the next 12 months. It'll be something, you know? Or not.
Kind of a unique piece of property. It is. Okay. All right. Anything else from the board? Okay. Paul, anything else? Yes, good.
We're all set.
All right. At this point, I'll open up to the public for anybody who's in favor of this proposal for KC 2524. And anybody in the public who is in opposition, if you'd like to come forward, anybody who's in opposition. That'd be a no. All right, at this point, I'll close it to public input. If the board's ready, we'll go to the worksheet. Say the variance will not be contrary to the public interest. It's a difficult piece of property that is zoned residential. It's for the proposed use, the congestion piece will be taken up by the DOT. I feel will not be contrary to the public interest.
I agree.
I agree it will not be contrary to public interest. The public has expressed an interest in growing the economic base of the town.
I agree. I think it'll be welcomed by most people for the reasons you stated before with the lines backing up at the stations now.
Okay, spirit of the ordinance. The request, in my opinion, is not in harmony with the spirit of the ordinance and the intent of the master plan. Even though the master plan does state that they want to in the future change zoning for that area, this is still not an allowable use for that particular lot. I know it's a difficult lot, it's a difficult place, but it's not in harmony with the zoning ordinance.
I think it is in harmony with the spirit of the zoning ordinance and the intent of the master plan. Master plan surveys have shown an interest in growing the base of that part of town.
I agree. I believe it is in harmony, and I think the location is actually a fair location because it's already a business area, that whole circle. It's growing, it's the future, I guess.
I agree. The request is in harmony.
By granting the variance, substantial justice will be done. It's a benefit to the applicant, which is not offset by detriment to the public.
I agree.
I agree.
I agree.
Values of the surrounding properties. one. Without doing studies on this type of thing, I believe it will not diminish the value of the surrounding properties. I don't think it'll, yeah, I believe it will not. I'll just leave it at that.
I believe the request will not diminish the value of the surrounding properties.
Agreed.
I agree that it will not.
And if a hardship for purposes of the subparagraph, unnecessary hardship means that owing to special conditions of the property that distinguish it from other properties in the area, one, no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property. Yes, and I believe the proposed use is a reasonable one.
I agree as well.
I think this is a difficult piece of property. It's unnecessary hardship. It's zoned in a way that's not really compatible with the areas around it, and that creates a hardship, and this variance would address that hardship. And the proposed use is a reasonable one. A service station is a good idea there.
I agree. On both.
Okay, so
Chairman,
we're go ahead. We're all five contrary. 4 of the 5 passed unanimously. The spirit of the ordinance passed favorably, 3-1.
Mr. Chairman, I'll make a motion then that we grant variance request from Article 400, Section 401D4 for an automotive service station in application Z25-24.
I second.
All in favor?
Aye.
Aye. Okay, gentlemen, you're all set.
Thank you very much.
Good luck.
I thought that second party wore you guys down.
That's it. I like being where you're right now.
Notice the volume on where you go.
Oh, yeah.
Okay. Moving on, previous business, we have the boards to select a second board member for the ZAC committee. Seeing that Frank isn't here, I'm going to nominate Frank for the ZAC committee.
Agree with that. I think that's an excellent choice.
I think
I just
Frank
want
might
the,
be on, he's on the,
Frank to be the ZAC.
listen to the budget, CIP. I think Frank's on the CIP.
Yes.
So I don't think you can be on all these ones.
Maybe.
No.
Yes. The last case was, yes. First Thursday of the month. Right.
Yeah.
Should be.
Yes. It's also posted on the front of the building and
So, Norma's saying she's not sure if Frank could be on the ZAC committee if he's on the CIP or CPI, whatever the committee is.
He can't be on both?
why can't he be on both?
I don't know.
Oh, I still say Frank.
He can do whatever we tell him.
I think Paul
Got some
would
broad
be
shoulders.
a good person on the
I'm on
ZAC
there.
committee.
I'm on there, Billy.
You're on ZAC committee?
I thought so, no?
But you want it.
There you go. Just
I'm on
back
there.
into the back.
Mhm.
Either way, we got,
You on this.
yeah, we got.
I think I was on there. I think I decided, I'm on the implementation of the master plan committee. Yeah, all right. But I
Thought we have a
well, if I'm not, I'll
That's
be
all.
willing to.
It's
Good,
implementation.
Oh,
Make
okay.
sure that it goes forward.
I got you.
Yeah, I'll go on Zach.
There you go.
Yeah,
That would be much appreciated.
That made Norma very happy. All right, the approval of the minutes.
To do it though, I'm gonna make him do it.
The approval of the minutes from May 1st.
Thing I would change,
Yeah.
on page 6 of 19. Where it says Mr. Larshaw 191, the word was used, requirement was actually should be equipment.
Oh, okay. That was on this page, right? Did you see
Line was
what
that?
they gave us?
Paul,
Yes. Right.
Huh?
which line?
That was, if you look on 191 where it says.
191.
Yeah, 191, you look at that, third, line down, it says, requirement, this actually said, meant equipment. And on the last page, 19 of 19, it's a real minor thing. There was a motion 7:51 to adjourn the meeting. The motion by Chair Lee was motion by Vice Chair Lee. Ha. Yes.
Holy
Wow,
crow.
you're right, it's really moving.
It's happening, that went through, it was happening.
And road number 186.
Really? You always know that through, huh?
You guys both have Robin's amendment to the minutes?
Yes. Mr. Rich's, I don't give a shit what they best say.
So, right. So with those amendments, I move that we approve the minutes for Thursday, May 1st, 2025.
I'll second that.
All in favor?
Aye.
I'm gonna abstain.
And anybody make a motion for an adjournment?
Motion to adjourn.
Second that.
All in favor?
Aye. I did not abstain on that.
Just not hard. Just because
Had a hard time with this application.
through that last
Yeah.
page, because it's not a change that has happened yet. Change down the road may happen. You know, I get it 100%, it'll probably never sell, but it is